We're on
So
the
you already
record.
have 6. Bye-bye. No.
Okay, it's called the meeting. Call the meeting to order of the Sunshine Ordinance Task Force at 5:14. Please call the roll.
On the call the roll. Member Eldon absent. Member Josh Wolf.
Present.
Wolf present. Copra absent. Member Tesfa absent. Member Moss.
Here.
Moss present. Member Kanata.
Here.
Kanata present. Member Fisher.
Present.
Fisher present. Member Hinsey.
Present.
Hinsey present. Vice Chair Highland.
Here.
Highland present. Chair Wolf.
Here.
Wolf present. We have a quorum. I would just like to note that item number 8 has been withdrawn by the complainant.
Any other changes, adjustments to the agenda? Questions? Okay. Let's call first item.
Next on the agenda is item number 2, approval of the minutes from the Sunshine Ordinance Task Force November 1st, 2017 meeting.
Any changes, adjustments to the minutes? Corrections? No? Public comment on the minutes? Seeing no public comment, can we take this by acclamation?
Is there a mover?
I move to approve.
Second.
Moved by Kanata, second by Enzi. Sorry, I'm jumping the gun. Okay. Any other discussion on the matter? Seeing none, can we take this by acclamation? Seeing no objection?
That motion is adopted with members Eldon, Copra, and Tesfa being absent.
Okay, please call the next item.
Next on the agenda, item number 3, file number 17121, hearing Ethics Commission draft enforcement regulation and enforcement of order of determinations by the Sunshine Ordinance Task Force.
Okay, I'll start the ball rolling. We had a visit from the Ethics Commission Deputy Director Jessica Blom, the Complaint Committee meeting, and we had a nice long discussion. I hope everybody had a chance to listen to the audio on that. They found an interesting way in reading the ordinance to help the task force get enforcement on its orders of determination. And as we know, in most of our referrals, they've been just into one section under 6734. This would allow for, if the task force was so inclined to refer a complaint for enforcement, it didn't have to be under 6734. And thus, if there were a package that was sent over, for instance, and the Ethics Commission said, wow, these are excessive, there's a lot of repetition or repeat violations here by the same person, this seems somewhat willful, they could themselves bump it up to 6734 and then deal with it in their own house. And there's a whole process for that that's laid out in this proposal. So with that, that's kind of the long and the short of it. So with that, I'll open it up. Jeff Pierce is here. He's one of the primary investigators in the investigation unit at the Ethics Commission. And he's here to answer any questions. Jessica Blom wasn't able to make it today. So Jeff is pretty well versed in this at this point. So if there are any questions, I just want to add that the Ethics Commission wants to have this on is going to have this on their agenda December 18th. We had tried to get them to move it up to January, but they refused. So we should think about, if we like what we hear and there isn't anything too outstanding, we should think about possibly taking action on this today. Okay. Member Kanata.
Yeah, so just so I just want to make sure I understood some of the audio correctly. One of the parts that interested me was that if the Sunshine Task Force sends something up to ethics and at the ethics hearing, new information is presented, the Ethics Commission will not adjudicate that matter. They'll send it back to Sunshine to adjudicate with the new information, and then it's up to Sunshine to determine if it goes back or not. Is that a proper understanding?
That's a proper understanding. The regulations provide for the possibility of what we would call remand, and the reason for that is that the Ethics Commission really wants to collaborate with the task force, and the Ethics Commission would consider the task force the primary fact finder when it comes to violations of the Sunshine Ordinance. And so if there were ever an instance in which a party had discovered new evidence, it wouldn't really suit the Ethics Commission to retry the entire factual scenario. And acknowledging the role that you play, we would send it back down to you. It's possible that our body or your body might want to develop some kind of policy, whether that's internal or officially in regulations, that would determine, that would somehow distinguish between proper newly discovered evidence and evidence that some party had been sitting on or cooked up as a way of trying to get the matter opened up again in hopes of a different result. That procedure doesn't yet exist, but I could envision either body creating one.
Thank you.
Mm-hmm. So just a little further clarification so when you'll hear certain terms from and phrases from the Ethics Commission side that they're used to using. They have an internal investigative unit, and they do most of that work in secret. They're not required to reveal what facts or evidence that are coming up in the middle of a case while it's under investigation. Well, what we do all our work in the public. So it was a little bit of a kind of getting on the same page in some of our conversation about how this would work. So when they mention fact-finding, that's usually, think of it as our complaint process. That's what they would consider the investigation portion of it. But one of the key things for this was, again, like you were asking, are they going to re-adjudicate stuff? And I think we kind of hashed that out pretty clearly, that we're really looking for the Ethics Commission to use its enforcement power and to use them as an enforcement arm as the next stage after what we do, doing the fact-finding, coming up with determination, and that we didn't want to see our ODs being overturned left and right. We wanted the respect, and that this be as a collaboration. It goes through this part to do all the fact-finding, and then once that's found, it goes for enforcement, and how they determine what the penalty, if there should be, or anything like that should be, that's up to them in their universe.
Mm-hmm.
Anything else? Okay, shall I open it for public comment, and then we'll see if anything else arises?
Mr. Chair, so
Vice Chair Howe.
just give me the timeline on this again. They're going to hear this
On the 18th, and they'll probably seek to approve it on the 18th.
and so this is our opportunity to provide any input. Is that
Right.
Okay.
That's right. That's why I was trying to push everybody to listen to the audio and read it through, because now we're on a short timeline.
It sounded like on the audio they were going to push it to January, though.
Right. We had asked that it would be January, and we just got word today?
This morning.
This morning, that they refused that.
Okay.
If I may, Chair Wolf,
Yeah.
the commission will invite your written comment, I believe, by December 14th. But of course, they would invite you also to attend the meeting on December 18th and provide oral comment at that time.
Right. I mean, obviously, it's a governing document, so it could always be amended at any time. But to get this kind of solidified, and basically what they did is there were two separate sets of guidelines. One for how does the Ethics Commission deal with sunshine complaints that comes directly to them, and another one for what happens when it's referred by the Sunshine Ordinance Task Force. So this is kind of a marrying of the two together. And if they receive through their front door a sunshine complaint that is not a 6734, the idea is that they would refer it to us directly. So we're not having a duplication of services or efforts here. Okay, I'm going to open it for public comment for a while. We'll let that roll and see where we end up. I want to make sure we have enough time for everybody's concerns, questions, and discussion. So, we can. I'd like to see if we can get to approve this today and send that resolution over to the Ethics Commission.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I'm kind of confused because I would like to know under what authority this gentleman and Ms. Bloom are making these negotiations with the task force. At the last Ethics Commission meeting, the chair, Peter Keene, said basically 80% of what you do is BS. And Quentin Kopp, who's also on the committee, said, I want to associate myself with those comments. And they also said that most of the people who bring complaints to the task force are a bunch of screwballs. And Chair Keene was very clear on the fact that he said screwballs and he meant screwballs. So while these low-level employees are coming here and doing these negotiations, you have the members of the commission who have to approve all this. And they're making negative comments about you, about the complainants that are coming before you, about the decisions you make and the referrals you make. So we've got this dual thing here. The people who actually have the authority are bad-mouthing you, and the lower-level employees are coming here saying, oh, we have this good faith effort. We want to enforce the task force. I mean, look at this. 2010, 2011, civil grand jury. Because the Ethics Commission's lack of enforcement, no city employee has been disciplined for failing to adhere to the Sunshine Ordinance. The Commission has allowed some city officials to ignore the rulings of the Sunshine Ordinance Task Force. They have never enforced one. The only one they even tried to enforce was against Jewel Gomez, and the mayor not only ignored the recommendation she be removed, but reappointed her. The task force, one of the things they talk about in the Good Government Guide is the role of commissioners. And when acting as a quasi-judicial body, they are supposed to make their determinations based on the facts and the law, and they are supposed to look at, they're supposed to provide due process for all of the complaints before them. Well, how do you call it due process when every single complaint that has ever been referred to the Ethics Commission has been denied? Every single one except for the Jewel Gomez one. And so basically they're saying we want to enforce this. Well, if they wanted to enforce it, they've had 18 years to enforce it. And they haven't once. They only tried once. So I'm just really confused here as to why we're having this representation from the staff saying that the Ethics Commission wants to enforce a regulation which they then in their own public meetings are bad-mouthing, calling the complainants screwballs and saying that 80% of what you do is bullshit. Yes, they use the BS term, because they're polite. But that's what BS means, isn't it? And I think what you're getting is a bunch of BS.
Thank you. Next speaker. Okay. Oh, yeah? Oh, okay, come on. Okay, everybody comfortable? Okay, go ahead.
Good afternoon, task force members. I'm Richard Nee, and I served on the task force from 2002 to 2014. I looked through the proposed regulations today and have some concerns and some questions. Under the regulations in Section 3E, it says findings of of no 67.34 violation would be referred back to the task force, and I'm wondering if that could create kind of a bouncing ball effect where it comes back here, you find 6734, you send it back to them and say, well, we already found no 6734. Maybe that's maybe I'm imagining something there, maybe I'm missing something there, but it might be something you want to get nailed down. One thing that, again, this kind of troubles me in Section 4B, 4E, and 10C. If the Director of Enforcement determines there's no violation occurred, the Executive Director may dismiss the complaint. That's exactly what got into Dutch with the Ethics Commission, or got them in Dutch with us, when John St. Croix was their Executive Director. You recall, those of you who were on the task force at that time, that Mr. St. Croix would find any specious reason he could to dismiss a complaint. Now, I'm not saying that's going to happen under Ms. Pelham. As I understand, there's been a kind of a sea change since she took over. Even so, her successor might be another St. Croix. So that's something that you might want to address. Last but not least, and this is not really of concern to the task force and to Sunshine per se, but I noticed that in a number of sections there are use of Latin terms, subpoena ducis tecum, de minimis, and de novo, and I would suggest that you might want to suggest to the Ethics Commission that they keep their terms in lay English.
Thank you. Next speaker. No other speakers? Okay, Mr. Pierce. Come back up, please. So, task force members, any other questions? Yeah, Member Moss.
I just, I listened to the recording and I've read through this. One of the things I noticed is in the process of a hearing, where it differs from how the task force does it, is that we have 5 minutes, then witnesses, and then we have an opportunity for rebuttals. The Ethics Commission does not allow for that in that. In the procedure laid out. Is there a reason for that?
Are you talking specifically about the show cause hearing, or our hearings generally?
I'm looking at just the Section 10 section, the enforcement of orders determination by the Sunshine Task Force.
Okay, so that's probably...
And then it says hearing procedures. I think it's
right.
B13.
5 minutes for task force, complainant, respondent, witnesses 3 minutes. So my assumption there is coming back again to our language, which is that we consider the task force to be the fact finder. And actually, I think by fact finder, we mean not only that you conduct the investigation, but that you decide the facts. So there will be competing facts, not alternate facts, but competing facts in an investigation, because the complainant will have one view of the facts, the respondent will have another view, and you're charged with deciding which are the actual facts. So you decide the facts there, and that process may take longer. So what we do on a referral is a show cause hearing, and you can see that under B1I there, standard of proof, the respondent bears the burden of showing that they did not violate the Sunshine Ordinance, and that's because you already determined that they did. And so the burden shifts to them at a show cause hearing. The procedure is a little bit stripped down than what it would be, because, again, we're not looking to re-adjudicate what you've already determined, but to figure out whether we agree with the outcome before we exercise our enforcement authority. And so the procedure is it's more contained. But if you imagine that it should be expanded, we would consider that.
Yeah, I mean, it's strange to have it where if the complainant is the one going first in these hearings, then the respondent gets to speak and make whatever claims they're going to make, and the complainant doesn't have a chance to address those claims made by the respondent, then that can create an imbalance where the respondent has the ability to counter what was said but not have their words contradicted.
I would proffer this, that we might want to think about the Ethics Commission's role as more like the sentencing hearing. So if you think about, a regular court case, you have the the main trial to find all the facts and evidence, and there comes a finding of a violation. And then once that's over, that doesn't get challenged. It goes right to a sentencing hearing. And that's kind of what I'm kind of looking at this to be. Because at a sentencing hearing, the facts don't get re-adjudicated. It's just what does this particular violation call for with regards to, in relation to a schedule of penalties or certain kinds of enforcement or what have you.
I can see that. It's just that the section right before that says that the commission can review the conclusions independently or they can do it de novo. So there seems like there is the opportunity for that not to serve a sentencing function, but as a re-adjudication.
I agree. I'm not saying that we should accept all of this wholesale. So if you have any changes or suggestions for changes, I mean, this is something they brought to us. This is what staff brought to us because they're consolidating, a lot of their guidelines, I suppose. Is that correct?
Yeah, this is a thorough editing of all of our enforcement regulations. Incorporating the Sunshine Ordinance Task Force regs is just a part of an overall project.
Okay.
Then I think in that case, I mean, either the chance for rebuttal or that the respondent should be required to go first and then the complainant would go second, because if it's coming to the Ethics Commission with already a finding, then the burden is on the respondent to show why the finding of the Sunshine Task Force was wrong. Then they can make their case, and then the original complainant can then do their statement.
Well, so I'm a little confused there, because if I really want to think about this as more like a sentencing hearing, where you can't then go back and challenge the original complaint. The only thing you're challenging for is a lesser sentence, a lesser penalty.
I'm not sure we're saying different things. I'm specifically just talking about the process in which people get to speak at the hearing that they have.
What I'm saying is I think that process is not. Well, the question is what. If it's just a matter of how many minutes people get to speak and how they speak, that's one thing. The question is what the context of the discussion is. I guess that's what I'm getting caught up on.
But my thought is just the order.
Just the order.
And that whoever speaks first should always have a chance to counter things.
Do you have a suggestion?
I mean, it would be that there be just like similar to ours, there'd be a chance for rebuttals, whatever minutes that the Ethics Commission feels is appropriate for rebuttals. I mean, I'm fine with 3 or 5, or we do 3. Is that the rebuttals for us?
3 minutes for rebuttal.
And I think that would probably be a good way to mirror it.
So you want to suggest adding time for rebuttal?
Yeah.
Of 3 minutes each for each party.
Yeah, that would be mine.
And through the chair?
Yes.
If it's the Sunshine Ordinance Task Force opinion that this should be a sentencing hearing, then the wording in Section 10B1I, to me, should be changed, because that wording says the respondents will have the burden of proof, to prove that he or she did not commit a violation. Mm-hmm. And to me, that gives them the opportunity to say, no, Sunshine Ordinance made a mistake, I didn't do it.
Right. We brought that up during the complaint committee hearing. Is there anything you want to comment on that, Mr. Pierce?
Sure.
Did that come through from commissioners, or was that came through existing language, or
did what come through existing?
Section 10B1I, under standard of proof.
I could consult the original language, but or rather the language of the existing regulations pertaining to our enforcement of the Sunshine Ordinance. But I mean, I can tell you that I think this will be an ongoing point of some disagreement, and this came up during the meeting that we had last week. We are aware that you have ongoing concerns, as you put it, about the survivability of the determinations that the task force makes. As an enforcement body, the Ethics Commission, as we communicated last week, will always want to assure itself that when it exercises its enforcement power, it does so lawfully and with authority and to its own satisfaction. And so what you see in this language is a suggestion, respectfully, Chair Wolf, that I do not believe the Ethics Commission will consider these sentencing hearings. The Ethics Commission, again, will defer to your findings of fact, but you can see that the language is that the Commission will do that where appropriate. Meaning, I think you would have to be, outrageously wrong on the facts. You'd have to have committed clear error for the Ethics Commissioners to want to depart from your finding of facts. But that language that they would review the law independently or de novo suggests that they will decide for themselves how to apply the law to the facts that you found. I would guess that in most cases for referrals, but putting aside 6734, because that's original jurisdiction for the Commission, I would guess that with respect to most referrals coming from you, not alleging willful misconduct, they will agree with you. But
there's no confidence for that. So, that being survivable from appointment to appointment of commissioners, the tenures of commissioners. My concern is, because now that you're saying it that way, I've had some time to think about this. I don't want this body. I won't speak for everyone here, but I don't want this body to be relegated to being the same as your department, just the investigative portion. Okay? That's not how this was set up. And that is not how the ordinance was meant for this body to operate. If this body was given the enforcement power, it would just make its order of determination and then have essentially a sentencing hearing. Correct. For how the enforcement would happen. And that's the way we interpret, or at least I interpret, and I think many of my colleagues and predecessors have interpreted the ordinance to be. And the reluctance of the Ethics Commission to enforce even just the 6734 findings. Member testify.
So I was present at the Complaints Committee meeting where we discussed this issue, and so I just wanted to state for everyone else on the task force what my concerns were. It's on the same issue. When the Sunshine Ordinance Task Force issues an order of determination, like many other administrative type bodies, an order includes both a finding of fact and a conclusion of law. I've heard the speaker many times to say today that the Ethics Commission is willing to recognize this body for its findings of fact, but it's missing that portion on the conclusions of law. And whenever this organization or the task force issues an order, it is because we have applied the facts to the law. That's why there's a findings of fact and a conclusion of law. So the idea that we would be thought of as only being finders of fact, when each of our orders of determination clearly states that there are both findings of fact and conclusions of law, would be a misrepresentation of the activity that's the proceedings that are coming before us and that we are participating in. It would also be a misunderstanding of the way most administrative bodies work. That's an order is based on findings of fact and conclusions of law, not only one or the other. So that's just something that I wanted to explain here. In my practice as an attorney at administrative bodies, I have written many findings of fact, conclusions of law, and orders, and they all go together. You can't write an order without a finding of fact and a conclusion of law. So if the Ethics Commission is interpreting our orders of determination as only including the findings of fact, it's a misunderstanding of what our organization does. That's my feeling about this issue.
So I don't know if you may not have heard, the Ethics Commission wants to take this up on December 18th. They did not want it to extend it to January. So we're either compelled to make it, come to an agreement today on items that we want to suggest to them or urge them to make adjustments on or amendments, or not. And they'll accept ongoing communications from us for making edits once this gets passed by them. So if you have some specific language that we might want to move forward to them, then I would suggest we try to do that today.
Through the chair, I think I heard Mr. Pierce say up until December 14th. Is that correct?
For written comment, correct. Yeah.
Right, but this is the only day we're going to be together until the 19th, and that's going to be one day after the meeting, so that's why I'm suggesting this. Yes, go ahead.
Yeah, if I may, Chair Wolf, member testify. I do want to clarify. Certainly, your understanding of how administrative bodies operate is correct, and I don't wish to speak for the Ethics Commission and suggest that your body lacks the ability to render a conclusion of law. That is not my intent, and I don't know that commissioners would agree with that. I think what I want to emphasize is that the commission finds that that your body is the primary fact finder. You also render conclusions of law, but the commission has decided to retain for itself the ability to review your conclusions of law. That's not to say that you don't make them, and that's not to say that you would make them wrong, but it is to say that the commission wishes to retain for itself the capacity to review them and disagree with you before it enforces.
But my concern about that is it's as if we're just like any other member of the public bringing a complaint forward. We think that this was a violation. So does any member of the public thinks it's a violation. Why are we treated, in a different standard? I mean, we are appointed members of the public and other professionals to kind of raise the bar up a little higher with an open public hearing. I mean, this is, and I understand what you're saying, that they most likely will do this or that, but there's nothing that makes that a requirement that they will accept our orders of determination to be, as Member testified said, a conclusion of law, and must regard it in that way with the full weight of it, and not refute it. I mean, if they flatly out disagree that there should have been a violation, just send it back with a memo, with of what their concerns are, and if we choose to reconsider it, then we will do that. And I think that's an appropriate way to work. I don't think that we are less than the Ethics Commission just because they have some authority for enforcement. Member testify.
I would also like to include that the Ethics Commission always has the option to not enforce our orders of determination. That is the authority that is delegated to the Ethics Commission. Our authority, the delegation of authority to us under the Sunshine Ordinance, is to find the facts, apply the facts to the law and the conclusions of law, and make the order of determination. So with the ethics not retaining retaining the opportunity to revise the conclusion of law, come to their own conclusion of law, that doesn't recognize what authority has been delegated to the Sunshine Ordinance Task Force. The Ethics Commission always has the opportunity under the Sunshine Ordinance to review the case and seek to choose a level of enforcement that is de minimis, and if that is their review of the case. as the appropriate enforcement action, and that is what I recognize as the authority of the Ethics Commission in this case. I still recognize our authority as that of finding the facts in the hearing, applying the facts to the law, and then writing an order of determination based on those findings of fact and conclusion of law. The Ethics Commission can choose to enforce that order of determination how it sees fit.
If the commission decided to do it that way, that they would exercise their discretion not to disagree with the task force, but instead to tailor its enforcement to its own determinations, whether that means a de minimis enforcement, as you say, or something more powerful, would that outcome be more satisfying to the task force?
It would be to me. I don't want to speak for the task force, but I'm just expressing how I feel so that we can come to a conclusion as a group.
Well, let me ask this. I think it would be better if we were to offer them, instead of concept, offer them some language. Even if it needs to be wordsmith, but just offer them some language that reflects what our senses of this, or what our interests are. Okay, so I have one that Member Moss brought forward, was to add to 10B1 III time for rebuttals at 3 minutes each. Member testify, do you want to offer some sample language or just a notion that we can... the only thing I wrote down was something like the order's determination of the Sunshine Ordinance Task Force shall be considered a conclusion of the law and should not be challenged.
Findings of fact and conclusions of law.
Okay.
Because in order to write an order, both of those pieces have to be there because you're applying the fact to the law.
Shall be considered findings of fact, but also conclusions of law, and should they not be re-adjudicated or not be...
Sure.
So we're going to offer these items. You can bring them back, and then we'll see what happens then. Yeah, go ahead.
And then to that section, there could also be added language to state that the Ethics Commission may apply enforcement as it deems appropriate to reflect the findings of fact, conclusion of law, and order of determination of the Sunshine Ordinance Task Force.
Okay.
Which would reflect the idea that they could apply a de minimis enforcement or whatever level of enforcement they see fit.
Member Kanata and Member Moss.
So if we're going down this path, should we ask them to take out any language in here? And there's just in Section 10, there's a few of these paragraphs that have language that says the respondent can re-argue their case.
Right. So make a suggestion, and so we can, if we want to vote on it, we can have a cohesive.
Again, putting it out here to the lawyers on our task force, but a show. If what we're saying is that the Ethics Commission should apply penalty when we send them something at the penalty at their discretion, why is there a show cause hearing? So I would get rid of that B1.
Get rid of all of B1, you're saying, and replace it with just do the enforcement, and
replace it with the language we've been talking about, where our judgment, our findings of fact and rules of law, and that the Ethics Commission should apply penalty as they see fit. Some type of language like that.
I just think...
Go ahead, Member Moss.
I just had a minor thing to add. I thought that it would be useful in section 10, under item C, which is where they're talking about the final decision. I think it would be helpful if there was a line in there about that final decision being transmitted back to the Sunshine Ordinance Task Force so that we have a record of what their decision was, and Victor doesn't have to go pull that from their meeting minutes, so that it's actually formalized part of their process, that we get a copy of that we can add back into the file that we're keeping.
Okay, member testify. Go ahead.
From the comments that I've made earlier today, I'm trying to explain that the hearing that the Ethics Commission should be having, the arguments there by the party should be focused on what level of enforcement is appropriate based on the order of determination that the Sunshine Ordinance Task Force has already come to. So if they already know what the order of determination is, so at that point they could argue before the Ethics Commission that the enforcement level should be de minimis, or it should be whatever else could possibly be issued.
Let's wordsmith this a little bit. So instead of a show cause hearing, what would you call it instead?
Enforcement hearing.
Okay. So let's start with that. So we're gonna try and do something here, and we'll see if it flies.
As I'm sure the speaker knows, and as I know the task force members know, those who have had an order of determination by the task force do have the opportunity to ask for a rehearing on certain issues. Mm-hmm. And during my time here, we have entertained those rehearings. And so if someone doesn't agree with the order of determination, they do have that opportunity. And I don't believe that that opportunity should also, that they should be able to avail themselves of an opportunity like that before the Ethics Commission as well.
Okay. Would you say, members, that for 10B1I, instead of noting it being a standard of proof, that it would be, instead of saying that the respondents will have the burden to prove that he or she did not commit a violation, instead would be like argue the level of penalty or enforcement instead?
That's how I feel. I don't know how the others feel.
I agree with that, yeah.
Anybody else want to comment on that? Okay. Is there anything else that pops out for folks?
In the section standard of review, there I think it would be appropriate to have language that the Ethics Commission will defer to the findings of fact, conclusions of law and order of determination set forth by the Sunshine Ordinance Task Force. And that the Ethics Commission will be determining an enforcement action based on those findings, conclusions, and order.
Okay, I'm just trying to take some notes. So, okay, let me just make sure I got this. So in 10B12 under standard review, where appropriate, the commission will defer to the findings of fact and conclusion.
The findings of fact, conclusions of law, and order of determination.
Okay.
Set forth by the Sunshine Ordinance
Okay.
Task Force.
Okay.
And perhaps language that the commission will set forth an enforcement determination based on those findings of fact, conclusion of law, and order of determination.
Okay. Anything else?
Well, then number
Never come
3
out.
would have to either come out or be changed totally.
I think number 3 could stay there for the hearing procedure, in addition to the additional comments that Member Moss made. In the hearing procedure, the parties, the complainant, the respondent, and perhaps a member of the task force, if we want to do that, could be there to argue on the level of enforcement.
Okay, so if we're doing the wording, take out the showcase hearing in there, and it'd be the enforcement hearing?
Yeah, it would just replace the word show cause
Yeah, show
and
cause.
replace it with enforcement. I mean, I understand, this is how the Ethics Commission, does their business, because they have a whole separate staff-run department that does all the investigation and then presents that information, and then the respondent has the opportunity to refute the facts that come out of there. So
I thought the staff didn't do that. Didn't investigate the Sunshine Ordinance task
No,
force
no,
items.
not the Sunshine. I'm just saying other ethics, just their regular, because it seems to me here that they're trying to apply what they do for everything other than Sunshine to the Sunshine part, because it involves enforcement. I think there may be I don't know, correct me if I'm wrong, not culture, but maybe a context where they see that there's, in order to apply enforcement, they have to do a show cause hearing. And we're basically stating that the show cause part happens here, okay? And that the arguments, again, it goes back to that concept of a sentencing hearing where they can argue for a lesser sentence or for no enforcement at all. And then you would have then this the procedures like we have for time factors for people to argue that based on that context. So that's kind of, I think, where we're
Yeah,
going here.
that's mostly right. I mean, when the commission is hearing cases that the enforcement team presents related to violations of the other laws within our jurisdiction, we would refer to that as a hearing on the merits. And the procedures are quite a bit more robust because we have to go through the entire fact-finding process, and both sides argue law. A show cause hearing is limited to instances where an order has been made and the person against whom the order has been issued has an opportunity to show why that order shouldn't be enforced against them, why the penalty should not be applied. And it does come out of the civil litigation context. You're right that there is a kind of culture sort of, but there is one distinction.
But I think that you then, by that definition, you should agree then under B1I that it should not say that they have the burden of proof that he or she did not commit the violation.
Yeah, in the civil litigation context, when a show cause hearing is held, it's because the body holding the hearing is the same as the body that issued the order. So that body has already satisfied itself that the order ought to have been issued, and it's giving the respondent one more chance to plead some kind of circumstance of one kind or
and
another.
I think what our intention on this is that we're part of that process, and that shouldn't be rehashed.
If I may ask a question of the institutional memory of the task force. So the conversation that we're having is because 6735D grants this enforcement authority to the Ethics Commission, but it likewise grants it to any court of competent jurisdiction. And we talked a little bit last week about whether and how that happens. And you mentioned that if a complainant were to go into civil court, the court would ask if they had tried already
The local process.
Yeah, the whole process, whether they had what lawyers call exhausted their local remedies. Do you guys know, has anyone gone all the way to civil court, and what does the civil court do in that context?
I'm not familiar. It has. I don't recall. Maybe some past, maybe former
I think
task force member, Rick
Mr.
Nee.
Grossman, Alan Grossman.
But I don't know if I don't know if he took it to court. I know he took it.
He did.
He did.
Yes.
Okay. All right. I mean, I guess in essence, the same result would more or less happen, Mr. Petrellis? Okay. I think the same kind of result would kind of happen. If the Ethics Commission, if there wasn't this process, then the court would just go through the same thing. They would go through the show cause. They would go through whether the kind of the trial portion to find out if there was a violation or not, and then a sentencing of what the penalty should or should not be, or an order for change, like what would happen in a writ, a court order for change. So I think, I think once they've exhausted, this is just more evidence to show that there was at least an administrative process that doesn't clog up the courts, because this is more of an administrative process.
Yeah.
I think that's really kind of what it's all about. But the 6734, for what we're talking about, is not the 6734 item. We're talking about anything, any order of determination that we come out with that we feel requires enforcement.
I guess what I'm wondering is whether the task force believes that its orders of determination should also bind a court of competent jurisdiction, or whether you would distinguish between the Ethics Commission and a court in what procedures they can apply before enforcing orders.
Well, there's a little bit different level of hierarchy and authority here. I mean, that's a whole nother branch of government that's independent, and is meant to do that. I don't know that we hold the Ethics Commission at the same level.
And to clarify, the Ethics Commission would not hold itself out as.
I understand that, but
but
you see, that's what this is kind of feeling like. That that what we do with regards to is just simply fact finding. That's not what we consider what we do here. Is just fact-finding. We actually adjudicate to find a violation. It's just that we can't take it to the next step. And that the ordinance, we interpret the ordinance to be the next step would be for the Ethics Commission to just provide the enforcement and not re-adjudicate it, because that's what's happened in the past. That even though it's only been 6734 cases, they have re-adjudicated them, and then they just disappear. They just find that there's no violation. Meanwhile, there's actual fact finding multiple times. Okay? I mean, from many members of the public, multiple times, and it's clear case that there is a violation. And if they had the money to be able to go through to go across the street and file for a hearing, I think the court would find the same. Okay, and then would just say, okay, why wasn't there any enforcement? Why would the Ethics Commission think that it wasn't? We're going to overturn their ruling. That would not be good. I don't think the Ethics Commission would like for that to happen every single time. So I understand it's probably in their best interest to, if we have come to a conclusion, to find that they come to the same conclusion, okay? But it just seems like if we send an OD over for, an employee that failed to produce documents like 20 times, okay, on the same issue, okay, clearly that is a problem. Okay, and we'd like for that to be enforced. Is it going to be run through your investigative department to come, and then you're going to do the same exact work that we did, and then provide some sort of a recommendation to the commission? That's not what we want to have happen. We are, as far as we're concerned, as Member Tesfaye said, our order of determination should be considered a conclusion. So, Member Tesfaye.
Another distinction that I want to point out is, in my experience with orders to show cause, there are allegations of certain facts. And the idea that, and then you have the order to show cause so that the party can say that these allegations are untrue, these facts were misinterpreted, something like that. But the idea that we would be recognized for our findings of fact, but not for the conclusions of law, and that a full order to show cause hearing would take place, extremely discounts any of the work that was done here, even the finding of fact element. So the idea that you would have an order to show cause hearing, yet use all of our facts, doesn't really make sense to me, or from my experience of how federal and state orders to show cause are used in the administrative context. So they are usually orders to show cause and orders of investigation will be brought up at the initial allegation by staff or investigators that a violation has occurred, and it's starting the process. But we have already undergone a full process where people have been able to provide information. We've been able to ask information about that testimony in order to determine the veracity of that. So it's not like we are staff bringing an allegation of something occurring, or a complainant bringing an allegation of something, or petitioner bringing an allegation of something occurring. We've already determined that something has occurred. And that's why I don't think the use of the term order to show cause would be appropriate in this context.
Okay. All right. Anything else? Okay, so I just want to read back some of the things I've heard as suggestions. First, that we consider this enforcement process to be more like a sentencing hearing than a show cause hearing. That 10B should be renamed enforcement hearing. 10B1I, the orders of determination of the Sunshine Task Force should be considered findings of fact, conclusions of law. Wait a minute, that's one. I'm sorry. The respondent shall have the opportunity to argue the level of enforcement, and not argue whether they were in violation or not, which would be re-adjudicating the case. B1II, that the standard of review shall be based on the findings of fact, conclusions of law, and the order of determination of the Sunshine Task Force, and that enforcement shall be based upon those aspects. Okay. Okay, so the enforcement shall be based on, okay. Okay. And in B1II, time for rebuttals for 3 minutes, okay, for each party.
And changing show cause to enforcement.
Yeah, I got that. Okay. That was the first thing I said. Okay. Is there anything else? Member Moss.
Oh, just that. I mean, I just said in that that final, it was in the section C about transmitting their decision back to.
Oh yeah,
Sunshine
I
Task
got
Force.
that. Yeah, 10C, final decision comes back to the task force. Okay. All right. Is there a motion?
I'd like to make a motion to send these comments to the Ethics Commission for their consideration.
I'll second.
Moved by Member Tesfaye, second by Member Moss. Any other discussion from us? Public comment on the motion. Thank you, Mr. Pierce. Mr. Pierce, was there anything else you wanted to add? I didn't quite let you.
Well, thank you. No, only that Ms. Bloom has really appreciated this process of engagement, and I don't want your task force to feel disrespected. I do sense that there is that possibility. I would invite you, Member Tesfaye, to speak directly with Ms. Bloom. I'm certainly happy to convey your communications to her when she gets back, but I would invite you to speak with her yourself. And I think it could be valuable for commissioners to hear about your experience in the administrative process if you were able to attend on the 18th.
Thank you. Can I make a comment on that? I just think, I know that the Ethics Commission will do what they would like to do, but I think it's important that we file these comments and that it is out in the public, that we have noted our concerns, that the standing of the task force is potentially in jeopardy because of these the actions of the Ethics Commission, and that the public knows about that, and that we spoke up and tried to do our best. So.
Okay, great, thank you. And I just want to say that Ms. Blom has been very cordial and very open about it. It was at her initiation that she found this kind of section of the ordinance that allows for any complaint, any referral of violation of the ordinance to be forwarded for enforcement. So I appreciate her for that. As far as some of the things that we found, I think this is just all a matter of the documents that you're trying to consolidate together is just come into that way and under the rubric of how the Ethics Commission operates. And we just think that it's a different animal when it comes to sunshine complaints coming out of this body. That's all. Thank you very much.
Thank you.
Okay, let's have some public comment on the motion.
Is this the same public comment, or was the other?
No, it's just not the same. This is a public comment on the motion for the items that we just spoke about.
Before you, you have a list of 11 findings by this task force regarding the placement of 150-word summaries. 5 against the clerk of the board, and yet in October, once more, it went before the Ethics Commission, and the Ethics Commission voted unanimously that she did not violate the ordinance by failing to put the 150-word summaries in the minutes. Now, if you can have 11 orders of determination, each with a finding of fact and conclusion of law, and they still will not respect it, what do you think a sole referral has a chance of? A snowball in hell, perhaps? The Ethics Commission has no intention, and that's why earlier I raised the question as to who are they bargaining on behalf of? Who authorized Ms. Bloom and this gentleman to come here and parlay with you when the Ethics Commission at their last meeting was sitting there deriding you, saying 80% of what you do is BS? I mean, if the commissioners are speaking that way about you, what possible respect will they give your changes, your minor changes to this process? And if they can have, I mean, has any single item in the history of the task force been adjudicated by the task force as many times as the placement of the 150-word summaries? I would have to say no. In addition, the task force has sent out directives to all city departments saying in the minutes means in the minutes. It has sent a letter to the city attorney saying that it disagrees with his findings and statements in the Good Government Guide, that in the minutes it can include addendums and appendixes and all this other stuff. I mean, it boggles my mind to think that I go to Ethics Commission meetings and hear them denigrate you, denigrate the work you do, denigrate the complainants that bring matters before you. And, you know, hey, if they had a guy who filed 50 complaints and not one of them was supported, that's one thing. I've got 36 orders of determination, and I don't appreciate being called a screwball. I especially don't appreciate it when it comes to my First Amendment rights of free speech of having my 150-word summary relegated to an appendix where they proceeded with a prejudicial statement saying, "Oh, well, we don't verify that any of this is true." And I have a real hard time understanding why you are buying into this bait and switch thing they're doing with you, where they're saying, "Oh yeah, we're gonna pay attention to your findings of fact and conclusion of law," when you've got a case right here. 11 times this commission has ruled finding of facts, conclusion of law in the minutes means in the minutes, and yet in October the Ethics Commission said no, it doesn't. And the clerk of the board is not violating the Sunshine Ordinance by ignoring what the task force has ruled against her 5 times. So, I don't know whether you're in Alice in Wonderland or through the looking glass or what, but the Ethics Commission is hostile to the Sunshine Ordinance. They are hostile to the task force, and I don't think these people have any authority to be parlaying with you.
So I just, before we hear the next speaker, I just want to respond to that for a second. With regards to 6734 willful failure, that automatically, by the ordinance, is deemed as official misconduct. And I think there has been some reluctance of the Ethics Commission to take those up because it's a serious thing. It could unseat an elected official, as we saw in the Sheriff Mercarimi case. Here, if we refer anything, violations of any other part of the ordinance, it would not be considered official misconduct and may offer opportunities for them to have a little bit easier time in making enforcements and penalties without having to invoke official misconduct. Now, that could be, maybe there's a desire for it to be official misconduct, but that's why I was saying if we found that there were 10, violations and it was egregious, we could forward it with a recommendation for willful failure. It's up to them whether they would want to do that or not. But at least we would have an expectation, or at least an assurance that there would be at least an enforcement hearing on the items that we did send over. Okay, and if they want to penalize them, count 1, count 2, count 3, count 4, they can be my guest, go do that. And if it becomes very obvious that it happens again and again and again, and then they want to then find willful failure, they can do that. But I think there's been a reluctance for them to take up official misconduct because it involves a whole process. The mayor has to approve it. The mayor says that there's official misconduct. Then it comes back to the Ethics Commission for a completely independent, separate process. And so I think there's some value in this if we can make it work and we can get some collaboration with them, some agreement with them to at least start enforcing at least lesser than the 6734 cases. So I apologize. Next speaker, please.
I'm glad you apologized, but really, I've been here more than an hour now, and I don't understand why this item was put so high up on the agenda. And I'm mentioning the time I'm spending here because my complaint was filed in August. It's now December. What does this have to do with what you're debating? Let's assume that London Breed doesn't send anyone here, and I don't get what I've requested. And you guys make a determination that she should be turning over her block list on Twitter. And eventually my complaint gets to ethics. It'll be a few months from now. And then I have to go back, just come back to City Hall for another hearing and sit through another session with those blowhards who have made it known they don't give an F about people like me filing complaints or what you guys have to say? Who are you doing this for? Don't think you're doing it for me. And let me remind you that you did find a determination against Steve Cowa when he was the mayor's right hand that he didn't give me the documents. I had to wait months for that to be heard here, and then more months for it to get to Ethics Commission, and then I got to deal with these awful egos of Peter Keene, Kopp, Rene, and I forget who else is on that Ethics Commission. You want to send me over there again? Or any member of the public? That is not solving the problem. The problem is there's no enforcement taking place. I wish you would schedule high on the agenda turning on these cameras, telling us what you're doing, if you're doing anything, to get the cameras turned on. Because I believe the best thing that is going to help Sunshine, that is going to help democracy, that is going to help the average citizen is to have our complaints heard and seen on TV. You've taken up enough of my time tonight with the minutia of triple I this, triple I that, getting this guy to talk. It ain't gonna matter. Put us on TV. I have been here, I think, for 4 years now, literally begging this task force, turn on the cameras. Do something, at least put it on your agenda to give sunshine via the cameras to the Sunshine Task Force. And I don't want to be standing around here again with you guys putting this technical matter first before the complaints.
Any other public comment on the motion?
I ask that general public comment be the next matter on the agenda because I've waited 2.5 hours. I don't have a case here, and I just came for a public comment. Some of us work full-time, and it's kind of tiresome.
Any other public comment?
Good evening. I just want to say that I support your statement referred to the Ethics Commission. I believe that they don't have to reinvestigate the facts. After we have the hearing at least twice, okay, to have the determination issue. And if they don't want to do the work to penalize those people violating the law, I guess they have the such authority. But I don't agree with that. Thank you.
Thank you. Any other public comment? Seeing no public comment, you ready to vote? Please call the roll.
On that motion, Member Tesfa. The motion is to refer the comments from the task force regarding recommendations to the Ethics Commission for their consideration.
Okay. You want me to read them again?
No.
Okay.
Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Eldon, absent. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. I will work with Chair Wolf to prepare that memo and send it over to the Ethics Commission.
Okay. Please call for general public comment.
Item 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
Hi, members of the task force. I attended the November 7th, 2017 advisory committee meeting of the San Francisco Arts Commission. At the call for general public comment, I began reading from a 150-word summary. After the third sentence, Ann Trickey screamed, "You can't say that, you have to go." I said 5 times that she needed to reset her cell phone clock and that she was abridging my public comment. She ran out of the room. While she was gone, I read the 150-word summary in full and handed it to an advisory member. I have the audio and a video of that event. The summary was not included in the minutes. Ann Trickey returned twice with security guards who had their hands on me and tried to remove me from the room. I called Bill Graham, the director of security. He cracked open the door a bit, and he said, "No, you're not banned from the building." And clearly this is the most egregious violation of the Sunshine Ordinance, the First Amendment, the Brown Act. And so, but my issue is, as you know, the Arts Commission is completely clueless about these kind of things. I went to the full commission meeting here in City Hall 2 days ago, and I don't go very often because it's banging my head up against a brick wall. I read this identical statement, and there was no response at all. This is outrageous, what happened. Thank you.
Any other public comment, general public comment?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. Any or all of you may have different rationales as to what you think I'm trying to do and have been trying to do for the last 8 or 9 years, bringing complaints to the task force. But I wanted to make a matter of public record what members of the public have to put up with in this city when they simply go to a public meeting and ask to make a public comment and are repeatedly told, you can't say that, you can't talk about that, you can't go into this, you can talk about A but not B. All of it turns out to be BS. Like Michael Petrellis went to the Ethics Commission and he had a small sign and they held up the sign and both the Ethics Commission, all 5 of them are lawyers, and they say, oh, you can't hold up a sign, that's against the policy in the city hall, yada, yada, yada. And he and I went to a meeting with the sheriff, and the sheriff said, no, it is not against city policy. You can hold up a sign as long as it's not above a certain size, 11 by 17. So basically, you go as a member of the public to these meetings thinking my constitutional right to free speech is going to be honored, and it is not. And I haven't gone through this for grins and giggles. I've gone through it to show what a citizen of this city has to go through just to exercise their First Amendment rights, their rights under the Brown Act, their rights under the Sunshine Ordinance, and to document it. Now, earlier in the conversation, somebody talked about exhausting local remedies. I think with the last hearing before the Ethics Commission, I have exhausted local remedies as regards my 150-word summaries, which is, I will say it once again, and I've yet to have anybody disagree with me. It is constitutionally protected political free speech, and that protection extends to when the government publishes it in an official document, and it's different than what I actually said. I have the right to expect that the official record will include my 150-word summary because that's what I said. Not what you said I said, but what I actually said. And I don't think any citizen of this city, myself, any of you, or anybody else, should have to go to a public meeting and duke it out with members of a commission who think God gave them the right to interfere with public comment. It's like Quentin Kopp. You found him in violation, and basically his attitude is, I know I don't have the right. I'm a former judge, for God's sakes. I know I don't have the right to interrupt Mr. Hartz, but I do have the power. And not only do I have the power, I have the backing of all the other members of the Ethics Commission who will sit silently by, let me interrupt a member of the public and say not a word, despite the fact they all took an oath to support and defend the Constitution of the United States.
Next speaker.
Hello, Michael Petrellis again. I want to thank you all for your volunteer pro bono service to the public, to the government, and to democracy. I am back here at the microphone to say I think that your work will be enhanced if you put it on the agenda about turning the cameras on. And you know what? Some of you belong to some Democratic clubs. Get those clubs here. Tell us what the clubs are doing with their access to the Board of Soups. I come along to the Board of Soups. They don't even respond to my emails, phone calls. They want to shut the door as soon as I go there. You all have power with the Board of Soups, with the mayor. And you should be using it and pushing for the allocations of a small amount of funds to turn the cameras on in this room. I have also said this to the Housing Authority that I think meets here. I believe the Homeless Commission is now meeting here. There are a lot of reasons why this room needs to be fully wired to air the meetings that take place. I believe that if the Sunshine Ordinance Task Force meetings, these full monthly meetings, were aired on TV and more people were able to see, more taxpayers were able to see how the government is hiding documents from us and what public people have to go through to get documents, there'll be some changes. But right now, because for years these meetings are not broadcast, you're looking for solutions through the Ethics Commission. Okay, that's one avenue you can go through, but it is so cumbersome, and it really is not fair to expect the public to take an order of determination and go through those big egos when they're meeting there. So please put it on your agenda. What is happening with turning the cameras on in this room? And I want to thank Ann and Ray for all that they have done in terms of the 150-word statement and trying to get it into the minutes. I've tried that myself, and a lot of times it is really difficult. So I support what you have done in recent times to make us all aware of it and to get the public officials to do their jobs and include the 150-word statements. Thank you.
I just want to respond to what member of the public, Mr. Petrellis, had requested. The task force had as soon as these cameras went in, we had it on our agenda, and we had the folks that manage it come and talk to us about it. We requested a quote from them. They gave us a quote. It was about $30,000 for the year to run all our current meetings, as far as the committee meetings and this main meeting. But that came after the budget was already passed. So that's where we're at right now. Now it's where do we find money where it's already been allocated? Is there any extra money around? We do continue to ask for that. But we hope that it won't take another 2 years when the budget comes up again. So we're on it. We're trying our best, but it's not easy when we're not a body that is allocated a budget ourselves, and so we're trying to change that best we can. And as volunteers, it's hard at the same time. Okay. Any other public comment? General public comment.
Good evening. I want to say, you give us the time for comment. I would suggest that you give us a few minutes to answer some of the general questions about how you interpreted the Sunshine Law. For instance, last time there's a hearing about, I guess it's the case that attorney-client privilege. Is it the department claim that they have the privilege, then they don't have to hand to us all the document anytime related to the lawyer saying or email or any communication. So I just think if you can give us a few minutes to answer some general questions, not particularly.
I won't agree to do that here at this meeting right now.
Okay.
But I would invite any of the committees to put it on their agenda because there's a little more latitude on time.
Okay.
They can do that, and I think any of the committees could have that discussion.
Thank you.
You're welcome. Any other public comment? Seeing none, public comment is closed. Let's move to the next item.
Next on the agenda, item 4, file number 17095, complaint filed by Ray Hartz against Commissioner Paul Renee, your Ethics Commission, for allegedly violating Administrative Code Section 67.15D and 67.17 by privileging or prohibiting public criticism of policy, procedure, programs, or services of the city. This was heard by the Complaint Committee on October the 24th.
Complaint Committee Chair testified. Do you want to offer?
Yeah, good evening. So the Complaint Committee heard this matter. We felt that we had all of the facts in order to allow the matter to rise to the full task force. This complaint has to do with an incident that occurred in December of last year at an Ethics Commission meeting that was being chaired by Commissioner Kopp. At that meeting, Mr. Hartz had his public comment or his speaking time abridged. If this item sounds familiar, it has come before the task force before. This particular complaint is against Commissioner Rennie, as the clerk said, but when this item came before us, it was against Commissioner Kopp. In that order of determination, the task force, on its own motion, added all of the commissioners to the order of determination. And so that's something for you to consider today, that the task force has already found that Mr. Rennie, along with all of the other commissioners, were in violation of the Sunshine Ordinance by abridging, the Brown Act by abridging Mr. Hartz's speaking time at that December 2016 meeting of the Ethics Commission. Thank you.
Okay, let's start the process. May we have the petitioner complainant? 5 minutes.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and you've heard already that this this task force found a violation against Quentin Kopp because he was the actual person on the Ethics Commission who interrupted my speaking time. And the reason I filed this separately is because it includes additional facts that were not available at the time of the prior hearing. And that was a finding against Quentin Kopp for abridging my rights under the Sunshine Ordinance. Paul Rennie, who was at that time chair of the Ethics Commission, was also the chair of that meeting and was responsible for keeping order. And so basically, he allowed Commissioner Kopp to abridge my speaking time and did nothing to counteract that. And when I asked for compensatory time, he belittled it, and he basically said, your time's up, and it's only 7 seconds and stuff like that. Now, when your task force found the violation, I took it back to, it went to the Ethics Commission. The staff presented it to them. Most of them were smart enough to keep their mouths shut. But Commissioner Rennie did not. What he did is he talked to the deputy city attorney. He says, oh, is the task force telling us that we're not allowed to ask questions? And the city attorney could have played along with it, and he basically said, oh, no, they're not saying that you're not allowed to ask questions. They're saying that Mr. Hartz, as well as any other member of the public, has a certain allotted amount of time, and Mr. Hartz did not get his full time. So here we have a commissioner who is a lawyer, who knew what he was doing at the time he did it was wrong. In fact, later in the same meeting, at time 1 hour 42 minutes, he said to me on the next agenda item, he said, Mr. Hartz, do you want to make comment that you wanted to make on the earlier agenda item when your time ran out? And my response was, it's not germane to this agenda item, and it's a violation of the ordinance, and I wouldn't do that. Basically, he knew when he told me, no, you can't have that compensatory time, that he was violating the ordinance. He acknowledged it later in the meeting. And then when it came before the Ethics Commission, he denigrated your finding by pretending that it was something other than what you were saying. In other words, oh, we're not allowed to ask questions? Well, of course the task force didn't say you're not allowed to ask questions. And he knew at the time that Commissioner Kopp had violated my rights. As the chair of the meeting, the presiding officer, he allowed him to do it. He refused to give me compensatory time. He tried to adjust it later on in the same meeting. And then when it came back to the Ethics Commission that Quentin Kopp had been found in violation, he tried to marginalize it by having that little faux conversation with the deputy city attorney. Thomas Aquinas teaches that willful ignorance of what one ought to know is a mortal sin. Paul Rennie is an attorney. He knew what he was doing was wrong. He knew what Quentin Kopp had done was wrong. He aided and abetted him in doing it, and then tried to marginalize it and denigrate you and me, dismissing the complaint, saying, oh, no big deal, it was only so many seconds. It was a violation of the ordinance. And as I've said it before, the Ethics Commission has little or no regard for your findings. And in this particular case, Commissioner Rennie was trying to put on a little show where he could say, well, I didn't realize that what I was doing was wrong. That's willful. That's not just I didn't read one of the things. And Commissioner Rennie has been on the Ethics Commission longer than any currently serving member. He knows what the rules are. He's taken the sunshine training multiple times. And yet he went ahead and simply did it. And then when the order came back, instead of either A, keeping his mouth shut, which would have been the smart thing, or, which I think would have been the thing with a little bit of integrity, Judge Kopp should have said, Mr. Hartz, I am not withdrawing a single thing that I said, but I will apologize for interrupting your public comment inappropriately. I had no right to do that, and I shouldn't have done it. But what they did instead was denigrate your finding and denigrate me for bringing a complaint. Now, if I won't stand up for my own rights, who should I expect to stand up for me? Commissioner Rennie knew what he was doing was wrong, and he did it anyway. And that's unacceptable.
Thank you. Are any persons or witnesses on behalf of the petitioner complainant providing additional facts or evidence? Seeing none, respondent, 5 minutes.
Thank you, Chair Wolf and members of the task force. Jeff Pierce on behalf of the Ethics Commission and then Chair Paul Rennie. Respectfully, what I hear the complainant petitioner asking the task force to find now is a violation of 6734. He characterized then Chair Rennie's conduct as willful, which, as this task force knows, places this situation in the awkward position of belonging in the original jurisdiction to the Ethics Commission itself. But on the complaint that Mr. Hartz himself filed, he has instead alleged violations of 6715D and 6717. I think we can dispose of 6717 quickly because it doesn't apply to Mr. Hartz's situation. Instead, it applies to the rights of a member of a policy body, such as Mr. Rennie himself, sitting on the Ethics Commission. As to 6715D, I don't hear new facts in evidence before the commission that would pertain to a complaint on that issue. The facts that Mr. Hartz has alleged that would constitute a violation of that section of the ordinance occurred during the meeting and during Mr. Hartz's public comment. Any colloquy that Commissioner Rennie had with a deputy city attorney after the fact are not relevant to a complaint about 6715D. So if we can agree that the complaint is in fact about 6715D, and as Member Tesfaye has said, this body has already found the entire Ethics Commission to have violated Mr. Hartz's rights at that time. What Mr. Hartz is now asking you to do is to relitigate that same issue and to make a second and identical finding, specifically against Commissioner Rennie, whereas Commissioner Rennie is a part of the Ethics Commission, and so you have already found that Commissioner Rennie violated Mr. Hartz's rights. In the agenda item, you'll have seen a letter from Director Pelham that sets out basically a legal argument. There was public comment earlier that legal terminology is maybe tiresome to the lay public, and I can appreciate that. But this is a legal doctrine that truly applies in this case. So the doctrine of res judicata says that when two identical parties have litigated a claim against one another on a particular set of facts, that one party cannot litigate again those same facts against the other party on any claim that they brought the first time or any claim that they could have brought the first time on the same set of facts. So nothing would have prevented Mr. Hartz from naming Commissioner Rennie the first time around and from arguing the aiding and abetting concept the first time around, but he declined to do so, and this task force has already found against Commissioner Rennie. So res judicata says that these parties are identical. That claim has already been litigated on the same set of facts, So this task force is effectively prevented from litigating this, from hearing this a second time. If for some reason the task force disagrees and decides that Commissioner Rennie is not implicated in the idea that the task force, that the Ethics Commission as a whole was a respondent, then a related legal doctrine nonetheless allows Commissioner Rennie to effectively hold up a shield against Mr. Hartz's second and virtually identical complaint, and that's sort of a cousin to res judicata. It's called collateral estoppel, but it says that when an issue was actually decided in a previous case, and that issue was, did the commission violate Mr. Hartz's rights under 6715D? And this task force said yes. This task force necessarily decided that Commissioner Rennie, as part of the Ethics Commission, violated Mr. Hartz's rights under 6715D, and Mr. Hartz was a party to that action. Commissioner Rennie can now raise that as a defense and say, hey, Mr. Hartz brought that claim already. You decided it already. There's no reason that we should do this. If you decide to fine for Mr. Hartz today, you are making a decision that members of the public can bring serial litigation against commissioners on the same set of facts over and over again so that they can relitigate.
Okay, thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none, members. I have a question. Member testify. Was this a case that we had already adjudicated? It was.
We have, and it was originally brought against Commissioner Kopp, and then we, on our own motion, added all of the other commissioners to the order of determination.
Okay, so how did Commissioner Rennie's name come in as being independent of that? If it was started out with
there was a different action, different file number against Commissioner Kopp.
Oh, I
and then
see.
this item has now been filed to pull out Commissioner Rennie for aiding and abetting Commissioner Kopp for abridging the speaking time of the petitioner. So we have the original file number, which is not this file number, was against Commissioner Kopp.
16116. So that was back in December of 2016.
It was probably filed around that time, but the abridgment of the speaking time occurred on that date in both of the files. It was the same action that had occurred, the same abridgment.
And what do you think of the petitioner's or the respondent's argument?
67.17, that doesn't apply. That is the rights of people like us serving on these boards and commissions to be able to make public comments. And for 67.15D, we have already, if we had not added all of the other commissioners to our order of determination, I think there would have been a potential to entertain this item. But given that we have already added all of the other commissioners to the past order of determination, I don't think we can look at this item again.
Was this reconsideration?
No, it's a completely other complaint that was filed.
But it's a new complaint filed against something that was already adjudicated?
Yes.
Okay.
So the original
it's a little odd.
It is odd. The original complaint was filed against Commissioner Kopp only, and we, on our own motion, decided to add all of the other commissioners to the order of determination on the abridgment of the speaking time. The complainant did not originally bring it against all of the commissioners. We added that ourselves. So, after listening to all of the facts.
And okay. I think about it for a moment. Anybody else?
Through the chair.
Yep.
Member Tesfaye, just make sure I understand this correctly. So the original determination was against the whole body. And the complainant wants to bring this against one member of that body, but you're recommending that they include the whole body again.
No, I'm recommending, the complaint committee hasn't really been making official recommendations, but as we are hearing this item before all of us now, I don't think we can find a violation again because we have already adjudicated this matter. We have already found a violation for Commissioner Rennie and all of the other commissioners for the specific abridgment of speaking time that occurred in December of 2016.
And there's no additional facts or evidence to make this a separate incident?
We have found this exact violation against Commissioner Rennie already for this exact action that occurred.
Thank you.
Member Moss, did you have something to add?
No, I'm just, I feel like I'm on the same page as Member Tesfaye. And
Yeah, so I'm reading the OD, the order of determination dated March 15, 2017 for file number 16116. And it finds that Commissioner Kopp and the Ethics Commission violated 6715. So, okay.
Yes, on our own motion, we added the rest of them to the order of determination.
At that time?
Yes.
Okay, got it. Okay, so, all right. Okay, anything else for the good of the cause? Move to rebuttals. Okay, respondent, you have 3 minutes for rebuttal. If you choose.
Respondent submits the case.
Okay, great, thank you. Mr. Hartz?
Well, there's the case in a nutshell. I filed a complaint against a specific member of the Ethics Commission. You added the rest of the Ethics Commission without any discussion with me and thereby compromised my right to bring a separate action against a separate commissioner. You're basically saying that you can take an action which was not based on my complaint, which then compromises my right to bring a separate action against a particular member. And I don't think that's fair. I always intended to get a finding against Commissioner Kopp and then come back against Commissioner Rennie for allowing Commissioner Kopp to do what he did. Now, you may think, well, gee, that's fair. We were doing you some sort of a favor by including the entire Ethics Commission, but it turns out you didn't, did you? What you did was you prevented me from taking a separate action against two people who both did something wrong. It's not one size fits all or one punishment fits all. Very frankly, I mean, yes, I can see the argument about the consecutive. I could bring a complaint against each individual member of the Ethics Commission because Quentin Kopp violated my rights. Paul Rennie allowed him to do it, and then each of the other commissioners sat there and let them both do what they did. So yeah, I could bring 5 separate actions. But see, what you're doing is you added something on that was not in my complaint, was never intended to be in my complaint, and now it's being used against me to say in this particular thing, well, it's the same case. But it's not the same case. I don't know whether Commissioner Kopp was having a senile moment or whether he was just losing his temper. But I understood what he did. What I didn't understand was Commissioner Rennie, who was completely calm, completely in control, just deciding something that he knew was wrong and saying, no, you don't get any makeup time. And he went ahead and did it. And then when a decision came back, he denigrated the decision, deminimized it, by having that little faux conversation as if he, as an attorney, didn't understand what it was the task force had ruled. Oh, they're saying we can't ask questions. What? No, that's BS. He knew that wasn't the case. He knew what the task force said was that Commissioner Kopp took my time. So, yeah, we can have, is that what it's denigrated to, that the Sunshine Ordinance Task Force is now going to be the citizen against the lawyers? Is that's what it's turning out to be. Every time you get involved now, it turns out that the people who do the thing won't show up to answer for their own actions. They send an attorney to argue the law.
Anything else, members? Vice Chair Hyland?
Well, it seemed like a correct thing to do at the time this OD was first done back in March. And I just want to make sure that I'm gathering what we did correctly.
Yeah, I can speak to that if you'd like.
Yeah, and the second question is, if we hadn't done that, would we still be allowing, considering this as a separate case? I guess there's two parts.
When all the commissioners were added to the order of determination, it wasn't done after the fact. It was done publicly. Sure. And so the idea that we didn't do it in discussion with someone or with any of the parties or something like that, it was done in public. People had an opportunity to comment on the motion as was included in the order. And so the idea that and not only that, the Sunshine Ordinance Task Force has the authority to add people to the orders of determination who have been given notice, and the Ethics Commission was here to argue against, the motion that went with this order of determination. So we were within our rights.
Including Mr. Hartz at the time.
All of the parties that were given notice. He was given notice. He was there. The Ethics Commission. In this case, he was there. I would be concerned if the Ethics Commission wasn't present, and then we added all of them to the order of determination, and they couldn't speak up for themselves before we voted on the motion. So that's what I have to say.
Member Josh Wolf.
Except I think this does sort of bring attention to the actual process we have, which, if I understand this correctly, once we make our motion, the respondent and complainant have actually already had their last chance to talk. We don't allow them to speak in public comment on the motion. So Ray Hartz actually did not have a chance to
I can
go
comment
ahead.
on that. So I had been looking back at the record before we had the meeting, and their facts had come up at the meeting that made us want to add the commissioners to the motion. So it's not like that idea came, that one of us just added all the commissioners to the motion based on no information that they had done, that any of the others had done something also wrong. So their facts had been presented to us on that item that the other commissioners had done something wrong, that they had played a part in the abridgment of Mr. Hartz's time, and that is why we added them to the motion. So it wasn't just we added them to the motion based on no information, just to add them to the motion. So that information was part of the record, and that's why we added them to the motion in the order.
Member Moss.
Yeah, I just went and looked back at the original item, and I think that the way our form is set up, so for not this item, but the item that we heard back in March, and at the top of the complaint form that Mr. Hartz filed, it says complaint against which department or commission, and it says Ethics Commission. And then under the described violation, that is where it starts talking about Quentin Kopp. So I don't know that this was actually, like we could say definitively that the original complaint was just against member Kopp, because it did say Ethics Commission at the top. But I think that we've done in the past that it's totally fine for us to look at the facts and say that this is the agency as a whole that is culpable for a violation. But I don't necessarily want to see us in a case where we're having to have separate hearings for like a commission of like 11 people and having 11 separate hearings on the same facts.
Member Knopf.
It's just as a point of clarification, because I don't remember this instance, but I do remember in the past adding people to a complaint, but my memory is that we had the buy-in of the complainant at the time, and I don't remember if we discussed this with Mr. Hartz at that March hearing. It doesn't seem so by his comment, but I just wanted to get that out there. I don't remember getting that. And to Mr. Josh Wolf's comment about even though we had information which led us to include the rest of the commission, when the motion was made to include that it included the rest of the commission, there was no time for public comment by the petitioner or the respondent.
I can respond.
Just real quick.
Go ahead.
So this was your motion, Member Konada.
I know. I saw that. I don't remember how we got to the point of adding.
Yeah.
Member Tesfaye.
I just want to point out that even if you can think of instances where we have received the buy-in of the petitioner to add people to the complaint, we have the authority on our own motion to add anyone who has been noticed to that there are facts that show that they were part of this action to the order and to the motion, and that's what happened in this case. If we had added someone and the Ethics Commission was not present, like maybe they had been present at the complaint hearing, they agreed with what happened, and then they didn't show up at the full task force, and then we added all the commissioners to the motion, to the order, then there would be a notice issue, but that's not what occurred here. So we, on our own motion, we don't have to have the buy-in of any of the parties to add. If we see facts that look like a violation has occurred, then we can add people to a motion or order.
Vice Chair Hyland.
I'm just curious, in the original case, did Mr. Hartz describe both the Quentin Kopp cutting him off and reference Mr. Rennie standing by and then this other discussion? I don't think so, right? This is...
I believe all that information was there. There might have even been a recording. Mr. Hartz can clarify that issue.
That rings a bell.
We did watch the recording.
Yeah, so that's why we were able to see how everyone was acting at the meeting.
So I just want to say that I don't think it's the intention or was the intention or of the task force to subvert anybody's ability to to proceed with filing a complaint or anything like that. I don't know that we had any knowledge that Mr. Hartz was going to subsequently
8 months later.
Name, please. The additional rhetoric is not needed. That this was going to come up in this way. What I'm more concerned about is that it's very unusual procedurally, is that when we have a case that was already adjudicated and then trying to re-adjudicate it again on for the same exact thing, there is, I think it was, despite all the Latin and the legalese, it really comes down to double jeopardy, okay? I think it would have been far better if this item was brought up for reconsideration so that the record could have been corrected, okay? So that Mr. Hartz, if he wanted to name Commissioner Rennie in addition to Commissioner Kopp with regards to the order of determination, okay, for the same violation, well, because it had already been adjudicated, I think that would have been far more appropriate, and I wouldn't be squirming in my seat thinking that there's something wrong with this. I think that's where this is kind of like reopening a case and saying, well, there's more facts, there's more issues here. You didn't name the right people, or you should have named them all independently, and there should have been some additional narrative attached to one of the violators, or something like that. But I think trying to reopen an entire case to try and add, it's really is trying to, I'm just trying to amend what already has been happening. To me, this is more of a procedural issue than it is trying to find a new complaint. Because I agree, if the task force found that the Ethics Commission, if everybody was in violation of this, okay, but there was some, maybe later on it was Mr. Hartz found that it isn't correctly stated in some way, then I think it should come back as a reconsideration. And I would be more open to doing that than to then to close the complaint that Mr. Hartz has brought up, because he still feels somehow that there's been a violation. Let it come back and be corrected in that way.
I mean, there has been a violation, and that is the conclusion that we came to several months ago. We all saw everyone that was here that day heard the recording, and that is why we allowed all of the commissioners to be included in the order of determination. I think if maybe we were dealing with where we only had we saw the recording. We had the recording. If we did not have that information and certain facts were missing, then maybe this reconsideration that you're looking for would occur. But we didn't just add all the commissioners. We had the facts there that showed how people participated in this abridgment of the speech. So, and that's why they were included. So Commissioner Rennie was included in the order of determination. He was. I can't speak to his punishment or anything like that, but he was found in violation already for this matter. So I would hate to close this item as if he's getting not included or getting off or something like that. He was included.
So I'm not quite understanding what the closure is for this item now.
I mean, I would think the closure of this item would be that no one has a motion to find a violation because we've already found a violation. In the file number, I don't have the file number in front of me, but in the file number that we've had.
116.
Yes, because Commissioner Rennie was included in that for this exact set of facts.
Okay.
And the specific section of the Sunshine Ordinance.
All right. With that, is there a motion? I'll ask a second time. Is there a motion? Seeing no motion, the item is closed.
Did we have public comment on it?
Sorry?
Did we need a public comment on it?
There's no motion.
Okay.
Should we have some type of motion to declare the action that we're finding that
You want to make it
no
definitive?
additional action, just an affirmative action, and otherwise I would just describe what you...
Okay, I'll make a motion to not take any action on this item and close the matter.
Second.
Moved by Member Tesfaye, second by Member Hensy. Now, public comment.
There are several things. Firstly, by just naming the commission, it doesn't point to the commissioners of the commission. The commission could mean employees. It could mean the guy who takes out the garbage. The commission is not specific enough. And you see in his face page, page 36, he names name of individual contacted at the department or commission, Paul Renee. And in the previous complaint, he named Quentin Kopp. So he was very specific. Whether he filled out the page wrong in the initial complaint, whether the specific name should have been named, is difficult to say. But you have to jump into the mind of Ray Hartz, too. He attends a lot of meetings. He knows the law. And what set this off was that he made an off-color remark, and Quentin Kopp didn't like it. He got up out of his chair, he walked around for a couple seconds, and sat down. So what was going through his mind, we don't know. I did listen to that hearing. I was here, and it was shocking to listen to that audio tape. I remember it. But you have to understand that not everybody is Ray Hartz. Not everybody is going to come in here and file duplicative complaints of this nature. They don't have the expertise to do it. With Ray Hartz is kind of always reaching out and stepping over the line, or going out on a limb. He has the time to prepare these complaints, and I think he believed that Paul Reneg should have been named in the initial complaint on the order of determination. The commissioner's name should have been there.
Any other public comment? Seeing none, public comment is closed. I am going to allow this item if Mr. Hartz or if the Ethics Commission or Mr. Rennie or whoever wants to bring it back for reconsideration. I'm going to allow it.
That would be our complaint procedures only allows for 10 days after the order of determination has been issued. I believe if you want, you could make a motion to waive that rule for this matter.
Well, the item is now, you have a new file number now.
It would be amending the previous order, which would be 16116, which was issued several months ago. You could waive the complaint procedures to allow for reconsideration or something to that effect.
I'm open to that suggestion, and I think out of expediency, I would
through the chair
I would move to amend the motion to allow to waive the period of time to allow the item to be submitted for reconsideration, based on the fact that I'm compelled by what the public commenter said with regards to the Ethics Commission being a body, which includes a lot of people, and there's you can't if you were to make an enforcement of that, you couldn't enforce anything on the body. You could only enforce it on people, and the ordinance does speak to. It does speak to bodies, but here we're talking about specific people that were part of it. I would say that it's a matter of a correction in the listing of that there should have been a listing of the ethics commissioners and not just a inclusion of the whole commission itself. I made a motion. Is there a second?
Wait, that's a motion?
Motion to amend.
But there's another motion that's...
I'm amending that motion that's already on the floor before a vote.
Okay.
Even though we've heard public comment on it? That's okay?
Yeah.
Okay.
We don't have a second yet.
Doesn't the person who made the motion need to agree to the amendment, though?
No. That's only for a friendly amendment. I'm not making a friendly amendment because I don't think...
Wait, so you're just overpowering the amendment as chair, then, is what you're saying?
No, I'm not overpowering. It's a standard parliamentary procedure.
Nothing to do with being chair. He's just amending.
Wait, so a friendly amendment, the person needs to agree to it, but you can just make a non-friendly amendment, and their motion that had a second just is modified by whoever says so? I'm just
so the way it works is if there's a motion on the floor, somebody wants to make an amendment to that motion. There really is no such thing as a friendly amendment in parliamentary procedure and Robert's rules. There is no such thing. It's more of a courtesy to just kind of expedite things if it seems like there would be agreement. Okay? I don't sense there would be agreement to this. So I'm making a formal motion to amend, to add to the original motion. We will vote. If there's a second to my motion, then there will be public comment on my amendment, and then we will vote on the amendment. If the amendment is approved, then it is added to the primary or the initial motion.
And then we would vote on that.
And then we would vote on it all
motion.
together.
Got it.
Motion.
Sorry, I did not follow that earlier.
Member Kanata. Wait a minute. Is this a point of order?
Yeah, this is a point of order in the fact that can you have a motion that's covering two separate cases, one that's already been adjudicated and one that we're working on now? Because that's what your addition to the original motion was for the case we're on now. Your adding to the motion is for 16116.
Yeah, but that's substantive to this motion. It's substantive. This entire This entire case is about 16116. It's not about something else. And that's why the respondents are claiming double jeopardy. Okay? I'm saying, I'm kind of agreeing with them that it is double jeopardy, that this item should have been reopened to the point just before a vote was taken, that the process for bringing new evidence or whatever it is, if we agree, then we can agree or not whether that is correct or not, and then take the vote back on that particular item, because this is all inclusive of that item. I don't think that this item should have actually reached this place. I think it should have been sent back to Mr. Hartz to say, this needs to be reconsidered. It's already been adjudicated. You're looking for a correction.
Okay, but can we have two separate motions? One motion that was on the floor and seconded for file number 17095, and then your motion to waive the 1 month period for bringing back 16116.
I hear what you're saying. I have decided that I wanted to make a motion to amend. If there is no second, or if it fails, then I may do that.
Okay. I'll second.
Okay, so it's been moved by Chair, seconded by Member Josh Wolf. Any discussion? Public comment on the amendment to allow, to waive the rules and to allow this item, the petitioner to reconsider the item. Seeing no public comment, we can call the roll on this.
On the roll to amend.
Just on the amendment.
On the amendment, Chair Wolf as the mover.
Right, so aye.
Wolf, aye. Member Josh Wolf.
Aye.
Josh Wolf, aye. Eldon absent. Copra absent. Member Tesfa.
No.
Tesfa, no. Member Moss.
No.
Moss, no. Member Kanata.
No.
Kanata, no. Member Fisher.
No.
Fisher, no. Member Hinsey.
No.
Hinsey, no. Vice Chair Hyland.
Aye.
Hyland, aye. The motion fails.
Okay, so we're back to the original motion of just closing the case. Okay, any other comment about that?
Can I make a comment?
Yes.
I hear what you're saying, Chair Wolf, and I just hope that all of us will pay close attention to this matter going forward, and that if we want to reconsider who is listed in an order, that it takes place during the allotted amount of time so that parties can find closure in our decisions and understand that our decisions, when they end, they end in the allotted time that per our rules.
I got you. Okay, so call the roll.
On that motion, Member Tesfa.
Aye.
Tesfa, aye. Member Hinsey.
Aye.
Hinsey, aye. Eldon absent. Member Josh Wolf.
No.
Wolf, no. Copra absent. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
No.
Wolf, no. Motion passes.
Okay, so now I'm gonna make a motion to waive the rules to allow the petitioner or any of the parties to bring it back for reconsideration.
That'd be
file number 16116. Is there a second?
Second.
Moved by myself, Chair Wolf, second by Member Josh Wolf. Any discussion?
Again, I think this kind of action needs to occur within the allotted amount of time, and I hope that in the future that we can all be very detail-oriented and cognizant of what we are voting on this specific matter. I saw the tape. I saw how all of the commissioners acted, and that is why I voted for the motion as it was presented under the original file number. I think that our decisions need to be able to have some type of closure, and that actions need to be taken within our rules, sticking to our rules.
Okay, any other comment? Public comment? Seeing no public comment, please call roll.
On that motion, Chair Wolf.
Aye.
Wolf, aye. Member Josh Wolf.
Aye.
Josh Wolf, aye. Eldon absent. Copra absent. Member Tesfa.
No.
Tesfa, no. Member Moss.
No.
Moss, no. Member Kanata.
Aye.
Kanata, aye. Member Fisher. No. Fisher, no. Member Hinsey.
No.
Hinsey, no. Vice Chair Hyland.
No.
Hyland, no. The motion fails.
Okay. Call next item.
Next on the agenda, item number 6, file number 17094, complaint filed by Michael Petrellis against President London Breed, Board of Supervisors for allegedly violating Administrative Code, Section 67.25, by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Chair Wolf?
Yep.
I think Member Wolf is about to say this, but I think I'd like to move to recuse Member Wolf from this because it is almost exactly the same as the complaint he's brought before this committee. And so I think that he should not be ruling on a complaint that is the same as his one that he's filed.
Do you think you would be biased?
I feel like that a ruling
It
in
is
this one would be
his choice to make that decision.
Yeah,
It's
that's
not
Actually, the body. All right. Well,
I mean, if you ask me, I think that if
we would vote. We would vote to recuse if other members feel strongly that another member might be conflicted.
Why don't we hear from Member Wolf?
Well, wait. Let me finish. Let's finish what Member Moss was saying, and then
since this is a complaint that is exactly the same as Member Wolf's complaint, I believe that Member Wolf is unlikely to vote in a way that would undermine his previous complaint on this very issue.
Okay.
If he disagrees, I'd be willing to entertain.
Member Wolf.
So I don't disagree that the similarities between my complaint and this one are. I don't see any differences, to be honest. And so I don't think that I can be impartial. However, my understanding of the traditional recusal process would mean that I can't speak on behalf of the complainant either, and I feel that that's problematic too. So I don't know what the best solution here is, but I do feel that, in essence, I have a complaint that mirrors this that went to, I believe, compliance and amendments and never went anywhere from that, which is still sitting unresolved. And so someone want to respond?
I mean, is he able to prevent evidence as a person who has experienced a similar thing during the evidence portion of a witness portion?
Go ahead, Member Tesfaye.
The only comment I want to make is I understand what you're saying about Member Wolf. In this, with these specific facts, when it appeared before us, Mr. Petrellis had put in the request, and he had never received a response. Not only that, President Breed's office never sent any person to appear before the complaint committee and speak to the item. So I think that on the facts of they never responded at all to the IDR, I shouldn't say they're in violation. You guys are going to decide that. But we wouldn't necessarily even be deciding whether the documents need to be released or not. They haven't responded at all, and they haven't even appeared. So a determination on if there's a violation of an immediate disclosure request could come in the manner of they didn't respond at all. They could have responded and said they refused to turn this over because of a certain legal issue, and we could disagree with that, a privilege issue, something like that, any kind of issue. But we're barely even getting to really look at the merits of the case, whether something like this would need to be released, which would be very pertinent to Member Wolf's case. Of course, I would love to hear what Member Moss has to say to that, but I just wanted to clarify that in these facts, Mr. Petrellis has received at the time of the documents we have, he has received no response to the request, to a follow-up of the request, and they did not appear with a knowledgeable representative to talk about the case. So it's might be a little bit different from
Member Moss.
I think I would add that I think the issues that came up in Member Wolf's case Member Wolf's case may be referred to in the discussion ahead, and that also further complicates his impartiality in this.
Okay.
All right, since there's sounds like there may be some possible dispute to that, I think there should be a motion to recuse.
Wait, but we still haven't addressed the fact that basically traditional recusal process would mean that I would need to leave the room, and I feel that my voice in regards to this case should not be silent. So I don't really care whether I stay here or go there and speak as a public commenter or whatnot, but I do feel strongly that by the simple nature of serving on this committee and having filed a parallel complaint that I am completely silenced from both sides of the dais.
Member Wolf?
Yes, Member Moss.
I think that 67.17 means that Member Wolf retains his rights to speak on this matter, and that is what I feel about it.
As a member of the public.
As a member of the public and as a former complainant who has knowledge and issues of these matters, so yes.
I'm just wondering, do we have a written rule on recusal?
The task force itself does not have a specific rule. It's
usually when you are recused, you must leave the room completely.
I think that if we prevent Member Wolf from speaking his mind,
public officials must leave the room if they're recused.
They might influence their cohort
Right.
to make them feel guilty.
For
about
what it's worth, Member Wolf, in the past when we've had people, they've actually sat in the gallery, whether that's our policy or not, that's what's happening.
I understand, but that's actually not
For
appropriate.
recusals?
For recusals, because because your presence.
No, I
seen in
understand
the
your
room-
reasons, yes.
Yeah, Member Tesfaye.
Another comment I want to make on
And just a moment.
67.17.
Sorry, Mr. Petrolis. Okay.
When Member Pilpel used to recuse himself, he would go and sit in the gallery, and he would actually confer with the other side sometimes. But
right, Member Tesfaye.
And I just want to point out that I think with 67.17, the comment there is about their ability to comment publicly, not necessarily participate in public comment. So it would be a member of a policy body if they disagree with the vote of the policy body, if they want to speak to a newspaper or to anything like that, they are able to do that and retain their position. But 67.17, I don't believe it's referring to the actual time of public comment here. And in my experience working for administrative bodies, a commissioner will always leave the room because there is a presumption that their presence there will make their fellow commissioners feel guilty about something that they're saying or feel uncomfortable about speaking out on an issue that might negatively affect that commissioner. So.
Member Moss.
Well, I understand that 6717 does say the full constitutional rights of the citizen to comment, and I believe the Sunshine Ordinance would include the right to public comment as part of those constitutional rights.
But the one thing that the ordinance doesn't speak to is conflicts of interest, and that comes up in the Brown Act, I think. I'd have to research that out. But, yeah, Member Josh Wolf.
I think that as far as facts and evidence of the complainant would not necessarily have the full story presented to the Sunshine Task Force about this larger issue in conjunction with other facts unless I'm permitted to speak in providing facts or evidence on behalf of the complainant.
I mean, I'm perfectly fine with Member Wolf either presenting evidence or witness testimony during the hearing or during public comment. I have no problem with either of those happening. If people have issue with him sitting in the audience, he can hear just fine from the back room. I've sat in the back room, and then he can come out here to speak his piece when it's time. I'm not super concerned about that thing, but I do feel strongly that he shouldn't vote on it, but I also feel strongly that he should have the right to speak on it.
You can't have it both ways, kind of. But do you want him recused or don't you want him?
I do not think he should be voting on this matter.
Okay.
But I do think that if he is a witness to the event, to the issue, then he should be able to say so.
All right. If he's not willing to recuse himself, like get up and walk off the dais so that we are -1 as quorum, and then it needs to be a vote.
That's fine. I did make a motion.
That's
so.
not the question at hand. The question at hand is whether or not one that has recused themselves can speak to facts and evidence or not.
Okay.
Well, it says in the Brown Act you have to leave the room. So I think that we were either in the violation of the Brown Act or interpreting 67.17 how we want to. But it states that when a member has a conflict of interest or the appearance of a conflict of interest, he or she must publicly state the nature of the conflict unless the item is on the consent calendar. The member must step down from the dais or table and leave the room until consideration of the particular item is finished. Completely finished.
When I can leave the room and still come to speak at the point that facts and evidence is allowed, though. Those aren't
Until
mutually...
the item is finished.
No.
Until the item is finished. Well, and it also says the member may consult the city attorney if he or she has a question about whether or not. So I wish.
I would like to consult the city attorney on this issue because I feel that first off, I don't think I actually have a conflict because I made a request for the same information that our complainant did, but there is no actual conflict between me and the complainants. This is completely outside of the normal conflict of interest stuff, but my experience in filing my complaint is directly related to the complainant's experience in this case. Therefore, it's vital information to his case. So I don't know what the best way to navigate this is.
Through the chair, I think what might help is the fact that your case hasn't gone anywhere yet, has it? I mean, nothing has happened where you've had to...
It's in committee. It's already been heard in committee.
But there's been no action on it. It hasn't been, there's been no due process on it. What I'm trying to say is...
It's in process.
Okay, but what I'm trying to argue is that because it hasn't really gotten anywhere, he's okay at this point. That's what I'm trying to argue.
It's gone through a hearing. I don't think that we could say it's done, but I guess it's in process, so...
Then limbo.
Member Tesfaye.
I think we should exercise caution. My apology to Mr. Petralis, though this could be to his advantage if he thinks that Member Wolf could provide helpful information to his case. But I think that, when this item appeared on the agenda, Member Wolf should have contacted the city attorney for a recommendation on this matter, and that one way or the other, we will all be held responsible for either being in violation of the Brown Act or the Sunshine Ordinance. And I don't want that on me. I don't want that on this organization, since we are the arbiters of open government in the city. So I think it would be better for all of us to hold.
Yeah.
Pardon?
Yeah, to vote on him being recused.
No, I would not like to vote on him being recused. I would like to hold this item in some fashion until another meeting, until we have a recommendation from the city attorney.
So
because I don't want to vote on his recusal, say he should be recused, and then I've violated 67.17 for him. So
One other question through the chair. Didn't you recuse yourself once before on because of this case? I seem to remember you did.
Yeah.
Go and sit in the...
yeah.
Whether it was during committee?
It was a different committee. I was in the room. I believe it was a different... I was in the room because there was a different committee, but I was... Can I respond to what Member Tesfaye said and then go back to that? Is that possible through the chair? What?
Yes, afterwards.
I was asking if I can respond to Member Tesfaye and then return to Member Hyland's inquiry. Sorry, I'll go ahead and direct this to the microphone. So I agree with the suggestion that we hold this. I do want to push back on the suggestion that I should have approached the city attorney ahead of the meeting. I did see this on there and felt that the best way to approach it with the city attorney was actually in the meeting. I had no idea the city attorney wouldn't be here, but I felt that to whatever extent this needed to be resolved, it should be resolved in the light of public. So I did think about contacting the city attorney ahead of time and chose not to. It didn't even occur to me he wouldn't be here. As for Member Hyland's response, there was a related issue. I don't think I was on the committee, though. I don't remember the details, unfortunately.
I think because I was there.
Member Hinsey.
You It was before the complaint committee, which you're not a member of, so I think you came as a member of the public.
So this is what happened. The complaint committee had me on there as an ad hoc member for a different discussion. I was only there for that discussion. Then the issue related to London Breed was there. So then I left and became a member of the public and ceased being an ad hoc member of the complaint committee.
So, the question is where's the gravity? Does gravity, the weight of the impartiality overrule the 6717 part with regards to public comment by members of a policy body? And so, the question is what holds the greater weight when it comes to that? Does it preserve? Does it hurt? Does the task force believe it will hurt or benefit the current case on the floor by your presence? Because there is a sense that your presence would provide a level of impartiality, or that your decision may not be impartial. Because of your existing case that's in process. So that's really the question, okay? And that's why anytime there's a question, I would put it to a vote, because generally if a person wants to recuse themselves and get up and walk off, that's one thing, okay, and leave the room. But it's another thing when another member wants to recuse a different member because they have a specific issue with that. I think that the body needs, as we're having a discussion about it, I think the body needs to determine that, whether there really is a conflict or not. It may be just his sense and nobody else's, or vice versa. I don't know. Vice Chair Highland.
Just see if I can untangle this. I'd almost like to rewind the clock and perhaps have Member Moss, it's just a hypothetical, if he withdraws his motion, allows Member Wolf to recuse himself or not, that might untangle us. At the end of the day, I think it is important to get this right, but it's also important to balance the complainant who's been waiting here a long time to have this case be heard. And if this gets continued to getting DCA Cola's advice, then I think we've done him a disservice. So I'm just trying to...
Well, I agree with that. And again, with more apologies for the inconvenience of this, but the process takes precedent. If a process isn't right, then he's not getting the benefit of justice if we're wrong. Okay? And it's better to be safe than sorry. Okay? So there's one of two things that could happen. There could be a motion to recuse, which I've heard a motion. Is there a second for that motion?
Not yet.
Okay, or we continue it. So first of all, when somebody makes a motion, we have to finish that process. We can't interrupt that process. So Member Moss made a motion to recuse Member Josh Wolf. Is there a second? I'm going to second that. Okay?
Through the chair.
Now, go ahead.
I was just going to say, by doing that, you well, all right, never mind.
Okay. Go ahead.
For someone to recuse themselves, they need to leave the room. At this time, I don't feel comfortable possibly abridging Member Wolf's rights under 67.17, and so I would not vote for this motion, and if this motion fails, I will propose continuing this item and getting a recommendation for the city attorney on how to proceed.
Okay. So I'm going to just provide a little parliamentary education. If you want to, you can replace the motion with an amendment. You could do that. or you can, as you suggested, Member Moss.
I just wanted to ask member to testify if for the section of the Brown Act so I can look at it.
Okay. I can just send it to you if you want. It's 2.25.150, conflicts of interest.
2.25, sorry.
.150, conflicts of interest, recusal from discussion and voting.
In government
And
code?
it'll be part C.
This is in the government code?
Yes.
Yeah, okay.
2.2?
Here, one second.
You say 2.2? It's in general provisions? No. Title 2? No.
So I'm lost because I thought Brown Act is like 54950.
Right.
Yeah, I mean, I think we need to have the city attorney look into this matter. I know that with the Brown Act recusal, the person has to leave the room. I have worked for commissions, and the commissioner always has to leave the room.
Is that with a financial conflict of interest, or is that just a general recusal?
General recusal, and that's where the commissioner might have an interest that's involved in the case.
Can I?
Go ahead, Member Joshua.
So it's my understanding that if there is a conflict, it pertains to an ongoing complaint that mirrors the facts and evidence related to, mirrors the facts of Mr. Petros's complaint. Can I just retract my complaint and just move forward?
You mean withdraw?
Withdraw?
There's a potential for you to bring the complaint again in the future, so I don't understand why we wouldn't.
Why would I bring
err
the
on the side of
complaint again in the
caution
future?
I would rather err on the side of caution when we are the organization that holds everyone else to this high standard. For us not to be checking with the city attorney for a recommendation on something like this, it doesn't make sense to me.
Right. So again, my objection is really that there are important facts and evidence that need to be stated around this case. I don't really care which way they're introduced. I'm not committed to voting on this. I certainly am not inclined to aggrandize this situation over whether or not there is a conflict, but I do think there's important information that needs to be conveyed into the case. So I don't know what the best way forward is other than to
The city attorney could
delay
advise
the
you
case.
on that.
What's that?
The city attorney could advise you on that.
That was literally what I had just
Okay.
said, but yes.
Member.
Through the chair, so what would happen if we took the next item first and Member Josh Wolf conferred with Mr. Petrellis on these facts and evidence that he thinks are so important, and then he recuses himself?
No, I need to testify to facts and evidence.
Okay.
Mr. Petrellis sat through the hearing that I had. He's aware of the same facts and evidence.
All right, Member Moss, and then I'm going to go to public comment.
So, I mean, we didn't apply this recusal, walk out of the room when Josh Wolf had his own complaint, because he has to be able to bring his own complaint because he has the same process. It feels to me that if he's serving as a witness with facts, that it's very, very similar and should be treated similarly. At this point, though, I'm starting to think that we just need to continue it as well because we haven't reached consensus here. I just feel it's very, very important that Member Wolf not vote on this if we want the vote to have legitimacy, simply just because he has something similar. Waiting for, the motion's out there. I'm still willing to vote for it, but you said you want to go to public comment.
Yeah, okay. Is there any public comment on this motion to recuse Member Wolf?
Hi, Michael Petrellis. The one matter I want to address right now related to just this motion, okay, is the dereliction of duty from the city attorney's office. This is really not okay. This is wrong. This is a major error that whether it's Nicholas, who was supposed to be here and is not here, if he is the only qualified person from the city attorney's office, that's wrong. There is this important separate matter that needs to be addressed in the future of the city attorney having a backup city attorney who is ready to come here if Nicholas can't be here. That's what I want to say. Thank you.
Yeah, we attempted that and nobody was available. Sorry. I know. It's inopportune. All right, Member Kanata. Okay. Anybody else? Any other public comment? Seeing none, shall we vote?
Repeat the motion, please.
Yeah, really.
This is the motion to recuse Member Josh Wolf.
Okay. Through the chair.
Yes. In the microphone, please, so everybody else can hear you.
So, thank you. So if there's 8 of us here, and Josh gets a vote in this too, right? So if 6 people say yes to this motion, then we've just removed Josh for this and sort of abrogated, is that the right word, his rights?
No, haven't abrogated his
No,
rights.
and then I believe after that, there would be
Menopause, I
a
forget
motion
my
to
words.
continue the matter to a future date.
So if this motion passes with 6
I
votes,
anticipate
he
an additional
leaves.
motion. I anticipate an additional motion to continue it to a future date.
Of which member Josh Wolf would not be able to vote because he'd been recused. Is that true?
But then he would have the time to get advice from a city
you're saying.
attorney, any city attorney.
Why are we making this motion in the first place? Why don't we just move this to next month
So-
and try to make Mr.
Okay.
It can be under there.
If I'm reading the room correctly, then I would like to withdraw the motion and can I procedurally do that?
Absolutely.
Okay, then I will make a motion and replace it with a motion to continue.
Okay. Is there a second?
You are the mover on that. I mean, you were the second on the
Oh, yeah.
original motion.
Sure. Yeah, well, but this is a new motion.
Oh, the new motion to
Yeah,
continue.
he withdrew the whole original motion.
I'll second that.
So moved by
Motion is
Member
to
Moss,
continue.
second by Member Tesfaye. Any other discussion on continuance? Any public comment on continuance?
Michael Petrellis again. I'm really glad that you're having this discussion. And if what comes out of this discussion is a continuance, I am fine with that. The larger issue for me is this member of the board, who is not just a member of the board, she's the president. She, in the past, has had sustained violations here where she has refused to turn over documents or she hasn't sent a staff member. I would like to be reminded of what Josh's complaint has to deal with. And part of the reason why I am going to be happy with whatever you decide right now is that I will come back. I believe London Breed may run for mayor, and I want all of these matters in the public record in case she does run for mayor. That's it.
Okay. Any other public comment? Seeing none. Member Moss?
So I just want to just say for the record in the recording that this whole thing makes me a little uncomfortable not starting out with a recusal on Josh Wolf. Like, I think that maybe in a perfect world, we could have figured out a way to continue to, I don't want people on record voting against a recusal on this matter because I feel like this is a very, very important matter before us. I still feel a little bit weird about Josh voting on a continuance on this, but I don't necessarily know how to deal with that procedurally.
Well, because it's procedural.
Right.
That's all. Nothing's happened. There's no partaking in the discussion of the subject or the details of the matter. So nothing's happened yet. Let's be assured of that. Okay. But at the same time, you could always bring up when this comes back up on our agenda to file that motion for recusal again. Okay.
That's fine. I think it's hard doing this without DCA Cola here.
Right.
I'm very nervous about this whole thing becoming tainted and us not
Yes.
being able to rule on this matter because I think this is probably one of the more important issues that's come before us this year.
I agree. Our integrity, it's important to maintain that, considering we are the arbiters. So, okay. And I would just let's vote on this, and I'm going to
On that motion, Member Moss.
Aye.
Moss, aye. Member Tesfa.
Aye.
Tesfa, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Eldon, absent. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, so I would just say that you can start out with DCA Cola, but you can ask any other city attorney because they represent the entire city's, all the commissions and everything like that. So,
Well, but I still feel that this should be discussed in the public space as opposed to me approaching the city attorney on my own time, which is why I didn't do that in the first place.
I hear you. I think we would have ended up with having to continue it anyway, possibly, because it's it's an edge issue, because you're wanting to be the idea of being recused and having to leave the room, but being able to maintain your ability to speak as a member of the public. That's what's at issue is here. Right. So that's what makes it somewhat complicated, and I am not confident. I'm not confident that we may have come to an answer if DCA Cola was here. Maybe we would have. I don't want to second guess him, but in the chance that there was he couldn't provide us an answer, we would have had to continue it anyway. So and then the discussion could come back later. In any case, when it comes back, you're going to have an answer for us. It could be a written, I would suggest a written opinion if you speak to a city attorney. That could be presented, and that becomes part of the public record too. So your discussion would not happen behind closed doors, so to speak. It would come out in a written opinion. Okay? All right. Thank you very much for all your patience. How many more do we got here?
In essence, 3 more.
Okay, shall we forge ahead? Okay, call the next item.
Next on the agenda, item 7, file number 17056, complaint filed by Denta Tedessa against Candace Carpenter and the Office of Citizen Complaint for allegedly violating Administrative Code, Section 67.21, by failing to respond to a public records request in a timely manner.
This was heard by...
It was heard by the Complaint Committee on 2 separate occasions.
I think we just found that it was within jurisdiction, the records are public.
Yes.
Okay, so there's not much else.
I believe that the department did provide justification. Sorry, I'm trying to find the right. Just to quote, Ms. Frankel stated that it is the policy of the department to not provide copies of investigative documents, but that they have met with the complainant and discussed the complaint over its non-disclosure agreement, and that I'll leave it at that. My apologies.
Okay. All right, well, we'll get more information. Are both parties here?
We are here.
Mr. Tedesco.
Oh, I'm sorry. I thought you meant both of the people from the Department of Police Accountability.
Yeah, no. We'll call you in a minute, if you don't mind.
It does not appear that Mr. Tedessa is present at this time.
Members, do we want to forge ahead with the case, or we usually have a requirement of the items?
Who's the lady that's here? Is she
representing the respondent?
I see.
It's the Office of Citizens Complaints. Member Josh Wolf.
I'm concerned about moving forward because at the complaint committee, the petitioner wasn't there either.
He was there at one of them. He appeared at one and did not appear at the second one, but he has been informed and he has appeared in the past on various issues.
Yeah, but we don't have our requirement is for the complaint process and not for the full hearing.
Well,
thought it was
Victor just informed me that he had been at one of them.
Yeah.
I was just reading the notes, and it appeared that he hadn't been at the complaint
Not
hearing.
for this item. I don't think.
He did appear at the June meeting of the complaint committee, but he did not appear at the July meeting.
What did we do with the June meeting versus the July meeting? I don't remember. Was the July meeting when we heard it on the merits?
Was that? Hold on.
Because I wasn't at the July meeting. I don't.
Member testify. Can you? I don't recall.
What's the question?
Well, it seems from the notes that the complaint committee found that the records were public and the matters in jurisdiction and referred it to here. And then there's a notation about a July hearing that Mr. Tedesco was not present at the hearing. Is that on a different case?
It was the same case. In June, the committee heard the matter. Mr. Tedesco appeared. I believe at that time we were not requiring the departments to show up, and we had additional questions for them. So the complaint committee continued it for 1 month.
Item. Okay, that's right.
And then they heard it in July. In the July meeting, Mr. Tedesco did not show up.
Right.
The department did, and at that point, it was referred to the full task force.
Right. Okay. Very good. That was the missing link. It was continued. Yeah, it was continued. Okay. So the question is, shall we move ahead since the petitioner is not here? Or should we?
Did he give any information to the
He
clerk?
did not provide any indication that he would not appear at today's meeting.
Well, with that, I would proceed, but that's just me. I want everyone to feel comfortable with that action. I think that if the respondent weren't here, we would proceed. So, I don't know.
Can proceed if you want. If you feel that the petitioner would not provide any additional.
I think that if we do come to a decision, that the petitioner will have the opportunity to reconsider the motion of determination. So,
okay, Member Josh Wolf.
If I'm reading this correctly, we've had one meeting where the petitioner was here, but the respondents weren't. We've had one meeting where the respondents were here, but the petitioner wasn't. And now another meeting with the respondents and not the petitioner. I realize that if we push this meeting back, there's a likelihood that we're going to not again have both parties here, but I don't really feel super comfortable moving forward on a complaint when we've never had both the respondent and complainant in the same meeting.
I mean, I'm confident that the respondent would show up to another meeting. The first meeting, when the respondent did not show up, it was because at that time it was not a requirement for the respondent to show up as part of our policy.
Just so I'm clear, I was in no way suggesting that the respondent wouldn't show up. I'm suggesting that perhaps the complainant might not or whatever. I'm just trying to say that it might not work, but I'd feel better pushing it back until we at least have one meeting or a second attempt to have both parties in the room at the same time.
I would offer first, upon review, whether you think there's enough, you have enough information from the record and from the documents that have or have not been presented in the details in the matter. And if you feel that you have enough information to be able to move ahead with the case, then I think that is where we should be focusing on, because the petitioner may think, I have nothing more to add. I'm just going to let it go the way it goes. If we choose to take this if we choose to proceed. Member testify.
First, that this item has been elevated to the full task force because the complaint committee felt that we had all of the facts necessary to make a determination of a violation or not a violation. So, we didn't make a recommendation, but it wouldn't be here today if we did not feel like we had all of the information, because that is now the complaint committee policy. And then second is the petitioner did receive notice of appearance, and the appearance was required for this matter. So, we have notice is a thing. We gave it to the person.
I would offer this. Let's start the proceeding. Let member testify, do the brief summary, and then we'll see how people feel as we proceed. If you really feel that there's not enough information, we've done this before. In the middle of a proceeding, we don't have enough information, we continue it till we get it. So, is there any objection to proceeding? Okay, seeing none, let's proceed, please. Member testified. Do you want to provide a summary?
From what I recall, an incident occurred. The Office of Citizens Complaints had received copy of a surveillance video from a bank that was within the vicinity of where this incident occurred. The petitioner would like access to that record that he knows is in the possession of the Office of Citizens Complaints. The Office of Citizens Complaints has brought the defense of this document was obtained from a third party via subpoena. Mr. Tedesse could obtain the document, the record, if he files a non-disclosure agreement, which he has declined to do so. So at this time, we'll be hearing from the Office of Citizens Complaints on their argument that this document was obtained in a way where the NDA must be signed in order for it to be released.
Okay, thank you. So we'll first start with the complainant. Complainant is not here. We've already established that. Are any persons or witnesses provide any facts or evidence on behalf of the complainant? Seeing none. Okay, respondent. Please state your name for the record.
Ines Vargas Frankel. I'm a senior staff attorney for what used to be the Office of Citizen Complaints. It is now the Department of Police Accountability. So if I go back and forth and say DPA instead of OCC, please bear with me. I do have a statement to make, and thank you for the briefing about the complainant's issues. We do have a slightly different version of what actually happened, and I have prepared a few remarks so that you can consider this matter in context of how our department functions. First of all, it seems to me that we have two issues here. One is at least what was stated in the agenda and in the complaint before, and that was that there was an issue about our department not responding timely within the 10 days or seeking an extension. And the second issue, of course, is what was mentioned here, are the documents or the video footage in this case that the petitioner was requesting, is it a public document, and whether or not he had a right to get it. So just in that context, I would like to just read off, not read off, but make a few points. The OCC, or the Department of Police Accountability, was created a long time ago by charter, 1983. Our basic purpose is to act as a civilian oversight agency, sort of an internal affairs unit, if you will, but not within the department, within the police department, but we are independent. All of this is to say that we have a very long history of dealing with complainants. As part of the process of our investigations, when our investigations are concluded, the parties, the complainant and the officers, are advised of preliminary findings. Those findings are presented also to the police chief. The complainants and the officers have the opportunity to contest that. they have an opportunity to come back and ask for an investigative hearing, which basically means they want everything revisited by a third party or they want us to reopen the case, but they have to have a good cause. What we advise them in the process of giving them a preliminary finding is that we tell them that if you're going to request an investigative hearing to contest the findings, meet with the investigator first. We call that a case review, and we encourage everybody to do so. The requirements of a case review are that, first of all, the parties that show up and are going to talk to the investigator have to sign a confidentiality agreement, because anything that is discussed is going to be of a confidential nature. The second thing is that there are no documents exchanged. It is basically a meeting where the party that's dissatisfied talks to or the party that's curious, if you will talk to the investigator about the process and what happened and how come they reached a certain finding. So this is an opportunity presented. Since the office or the agency was created and we've had case reviews, we've always had them verbal. So it's not so much in this case, as was pointed out, that the complainant did not sign a confidentiality agreement, although that was later a part of the attitude, sort of, not hostility, I shouldn't say that, the struggle between, what was producible and what was not. The real issue here is that we've had conversations in case reviews with complainants and with officers for years under the direction of many, many directors. And every once in a while, a complainant or an officer will ask to see something in the investigative file, and we have to tell them that it's not possible because it's not legal for us to share that information, and I'll go into that a little bit later. But we've always done it verbally. In this case, Mr. Tades asked for the surveillance video from a party that we subpoenaed information from. We explained to him that that we could not share any information that we had obtained or any evidence we had obtained in an investigation about police misconduct. We did that verbally. He later followed up in an email and said, I want this, I want to have this, and that sort of thing. What we realize after all of this is that when Mr. Tades actually filed with your task force, we realized that his request to us was actually a request under Sunshine Ordinance, under the Public Records Act. I mean, he didn't call it that, but we did not see it that way because our custom had not been to deal with these requests that way. All of this to say that
Mr. Chairman, would I like to note that 5 minutes has expired. Would you like to?
How many, do you have just the sentence to finish?
Yeah, I just have a tiny little bit more to close it up for you. I want to say that we now have a new director who has come in since this whole thing happened. And the new director has been advised of all this. Our director is Paul Henderson. And we are now in a position where we actually thank Mr. Tades for bringing this matter to light, because the DPA has now has a policy whereby every single verbal or written request under a case review situation or any situation, even if somebody just walks in and talks to the receptionist, everybody in the office has been advised of the policy. I have written a sample letter as a response. The staff has been advised to check with all the attorneys and the staff, and we are following this process. So we have actually changed our policy with respect to that particular situation, and we also have training.
All right, so before you go on,
okay.
Because we have a specific timed process here, you'll have an opportunity if any of the members want to ask you a question, or we can have you continue after we finish this initial process.
Understand.
Let's
Thank
just
you.
finish getting through our initial process, and then we can get to more of the meat of the matter once we do that. Otherwise, it prolongs the whole proceeding, if you don't mind. So just hold that thought, and we'll have you come back in just a moment. Are there any persons or witnesses on behalf of the respondent providing any additional facts or evidence? Seeing none. Members, would you like for her to proceed? Okay. Would you like to ask questions?
I have some questions.
Okay. Member Josh Wolf.
Hi. So I'm curious. So you have people sign this, you called it a confidential agreement. I think somewhere else we call it a non-disclosure agreement, but essentially something that is people promising not to speak about the information that's obtained. If someone were to sign that confidentiality agreement and then just blatantly violate it, what would be DPA's process after that happened?
I don't know, and I'm not prepared to discuss that, but I'm happy to look into it. We would probably have to deal with the police commission in that, because we do work under the auspices and supervision of the police commission.
And are you aware of anyone violating the confidentiality agreement in the past?
Not to my knowledge. Complainants have decided to talk about their cases to the press, and they have their own right. They have the right to talk about their issues. Whether they have actually violated the agreement of not talking about what was discussed at that sitting, I don't know.
And is this confidentiality agreement a standard form, or?
Yes, it's a standard form.
Do you happen to have one with you, or is there one in? I do not see one in the file.
I do happen to have one with me. Just to clarify, Mr. Wolf,
yes.
We do not, regardless of the signing of the agreement itself, none of the investigative files can be disclosed.
Sure, I understand that. I'm just trying to deconstruct this piece by piece. I'll end my questions for there and take a look at the confidentiality agreement if anyone else has questions.
Anyone else? Member Kanata?
I have a question. I don't see any written request in the files we have. So do we have the written request? Because according to the respondent, the request was made verbally and then followed up with an email. But I don't see that email. So I don't know what...
Even if it's verbal, okay, and it's already gone through the complaint process and there's agreement that a request was made, verbal requests are allowed under the ordinance.
Right. But the response was that a verbal request was made and they answered that verbal request. Now, whether that answer was sufficient or not is one thing, but if they answered the verbal request, at least there was no timely issue on a verbal request.
Well, the question is it's not on response time. Response is only in an IDR situation. In a 6721 regular request, if there was no response at all, that could be a violation right there. But here it's on
content.
Well, it says in a timely manner. Was that the original complaint?
I thought that was in a timely manner is always included in 67.21. It's just...
Because the question, then the question becomes, is this a timeliness issue, or is it that he didn't receive any documents at all, which is also a timeliness issue?
Just both 67.21 and then, I can't remember, is it 2.5 for IDR? They both include a number of days requirement. So timeliness always, no matter which complaint, no matter which section you bring it under, is an issue. So that should always be stated in the...
So let's ask Ms. Frankel. Is it Vargas Frankel? Is that how you like to be addressed?
Either way is
okay.
fine, thank you.
When did you respond to Mr. Tedeschi after he made his request?
When he made his verbal request, the investigator responded immediately and told him that these documents are confidential and therefore we cannot produce them.
Okay.
He then followed up with an email, don't know why, and he said, I still want these, and she kept conversing with him. In other words, she was responding to him by email. What we interpreted your agenda item to mean was that we did not formally give him the actual case law and the statutes that prohibited us from giving any documents or evidence from our files.
Okay, so he says...
Which we have cited for you.
Right. He says on page 64 on the intake form, delaying repeated questions and requests for me to review my own case information, along with being able to see footage from the incident and other notes or interviews given in my case that lead to the complaint being dismissed as unsustained on all counts. And reading through DCA Cola's memo, he pretty much focuses on withholding. So I think that's kind of where we're at here. It's really based on withholding and not necessarily a timeliness issue. Okay, so can we agree to that? Okay, great. I've got agreement from everyone that that's the case. So moving ahead with that, first I want to ask, based upon your opening statement, was there anything additional that's pertinent that you would like to finish?
Thank you. I appreciate that, Chair Wolf. I would, because my opening statement was based on the timeliness issue. Okay. So in terms of the merits, we have submitted a document. I dated it June 13 of this year in response to before we appeared before the committee. And that cites specific bases for both the Public Records Act and the Sunshine Ordinance, where there are exemptions to the requirement of making documents accessible or available to people who request them. I did cite the Public Records Act, Section 6254K, which says records where disclosure is not required, including, quote, records, the disclosure of which is exempted or prohibited pursuant to federal or state law, including but not limited to provisions of the Evidence Code relating to privilege. We also cited your own Sunshine Ordinance that does not require disclosure of information that is, quote, exempt from disclosure under express provisions of the California Public Records Act or of some other statute, close quote. That would be your Section 67.26, and also your Section 67.24, subsection A1A, that California law exempts disclosure of certain personnel information. Now, in the law behind those exemptions are, and I will cite you specifically which those are. If you will just bear with me for 1 second. They are documents shall be kept confidential and not disclosed to any member of the public except in accordance with applicable law. California Penal Code sections 832.7 and 832.8. Also, there's an evidence code sections that prohibit any disclosure of peace officer personnel records unless it's done by pitches motion in a criminal matter, and that is required. We require a court order through a pitches motion process in order to disclose any of our documents. There's also a case called Copley that prohibits disclosure of any peace officer personnel records. That's Copley Press Inc. versus Superior Court, 39 Cal 4th, 1272. Thank you. The evidence code section is sections 1043 to 1045. And again, I mentioned the two penal code sections. I think those are the ones that I want. Those are all the law, the bases under the law, which protect these documents from being disclosed under any circumstance.
Okay. I have a couple of questions. One is when did you provide the reasons for withholding to Mr. Tedeschi?
Mr. Tedeschi was told by the investigator that these documents were confidential. I don't believe that the investigator at that time gave him the specific code sections.
So that's a requirement.
And that is a requirement. That's why I was saying we did not do it formally.
Okay. Have you ever provided communication to him about
We have not had communication with Mr. Tedeschi after the case review.
Okay.
He did not want to sign the confidentiality agreement, and then he came to you. He has not communicated with us.
Okay, great.
Yeah, but we were happy to. He has seen our documents, I believe, that we submitted to you, but we are happy to formally do so if you...
So did he actually get to see these documents?
I believe that he received these documents that I just mentioned to you, were presented to you.
But not the ones he was requesting?
Oh, no, I'm talking about the response.
Oh, the response, right.
Yeah,
yes,
and all these citations are in that response.
Okay, great.
Yeah.
So are any of the records that he was requesting personnel files?
They're all personnel files because they're inside of an investigative file. In other words...
Are all investigations considered personnel files?
No, all investigations are considered peace officer investigation files, and the law is... We're not talking about personnel files as in an employment file. We're talking about peace officer investigation files.
Well, under Penal Code, and you cite it here, under Penal Code Section 832.8E, states that complaints and investigations of complaints regarding police officer misconduct or neglect of duty are personnel records.
Yes, but what I'm saying is that these are separate from public employment personnel records in that they're investigations of police officers, and there is California law that specifically protects peace officer investigation and personnel files.
There are
peace
two
officer
different
specifically.
classifications of personnel files. One is employment personnel, one is investigations.
What I was trying to distinguish, Chair Wolf, was that we all have personnel files as employees of the city, for example, and I was referring to these. Of course, they're personnel files because they're investigations, but there is California law that protects peace officer investigation files, which are personnel files.
Okay, I've been a peace officer before, so if there was a investigation against a peace officer for conduct in any kind of way, that investigation and that process is not necessarily part of a personnel file. There are separate rules with regards to those investigations from what I know and what I've read and what you presented. So that's why I'm trying to make sure that we all understand there's a distinction.
Okay.
Okay, to say that an investigation against a peace officer is a personnel record, it kind of then creates kind of a catch-all that prevents any information from being released at all, ever. And so that means that if there was any kind of investigation, that would also then could extend to investigation of anybody. That they're all personnel records and they all can't be released because they're all part of employment. So it kind of becomes a little bit of a catch-22. So
I'm only referring to peace officer investigation files.
Okay.
Whatever title we give them, there is specific law that says peace officer investigations, and their files, basically, whatever name we give them, are protected and can only be produced under court order or by court order. Otherwise, the agency is at fault, and the agency is committing an illegal act.
Let me ask okay, so whether the case is open and in process or whether it's closed, it's still not releasable?
Exactly.
Okay. Member Josh Wolf.
I was just responding that I think the Copley Act was designed to create such a catch-22 by design. Like, I think that because this process used to work much differently in the city of San Francisco before the Police Officers Bill of Rights and the Copley decision.
Okay.
So what we're looking at is how the state law has prevented records that might otherwise be public from being able to be accessible.
Okay, thank you. All right, so let me depart from those particular records. Let's get to okay. So I think what this is saying is that that these are records that are allowed by CPRA and the Sunshine Ordinance that can actually be withheld and not released.
Correct.
Versus public records with information on it that should not be disclosed, thus be redacted.
Right.
Okay. So let me move on to the video.
Can I explain one thing? The complainants, as well as police officers, are entitled to some records. They can get a copy of their own tape, audio tape, when they get interviewed. They are also entitled to copies of whatever it is that they bring to us. We just cannot share anything that we have discovered during the course of the investigation.
Can they receive any memos or reports?
No. They, of course, are at liberty to ask for the memos or reports from the police department if they are public records, but we cannot take them from our investigation and give them to them.
Okay. Let's talk about the video, okay? Did he receive a copy of the video?
No.
Why not?
The video is part of the evidence that we obtained in the investigation. He could
But is it part of a
ask
personnel
for it
record? Is it
himself.
part of an investigation?
The video was part of the investigation, yes.
Okay. Was it part of a personnel, an employee or a peace officer? Was it?
No, it was surveillance video, from what I understand. It was surveillance, but it was the peace officer, the police officer was involved in the video, so that's why we sought it. And so it was evidence that we obtained from a third party, but it was evidence we obtained in the course of our investigation.
So it's evidence you obtained from a third party?
Yes.
So, but there was no peace officer actually in the actual video itself?
The police officer was in the
Was
video.
in it.
That's
Okay.
why we requested it.
Okay.
Yes.
Okay.
Uh-huh.
Okay.
Yeah.
All right. That's all I have.
Thank you.
Anybody else? No, nothing? Okay. All right, well, let's move to rebuttals, okay? You have 3 minutes for any rebuttals if you feel you have anything. No?
No, thank you. If anybody has any questions, we're happy to oblige. But I do want to just reiterate that our this whole procedure has helped us not only comply with the California law and your ordinance, or our ordinance, if you will, but it's also helped us in terms of how we serve the public and continue the mission that we have to, that we are mandated to do.
We
Okay?
appreciate
Thank you.
that. Thank you. Okay, so the complainant's not here, so there's no further rebuttal. Is there a motion? Seeing no motion, there doesn't seem to be, Member testify. So, okay, seeing no positive motion for a violation, then let's have a motion to declare that that this case would be closed.
I'd like to make that motion.
Is there a second?
I'll second.
Moved by Member Tesfaye, second by Member Hinsey. Is there any public comment on the motion to close this case? Seeing none, please call roll.
On that motion, Member Tesfa.
Aye.
Tesfa, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Eldon Absent. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Thanks. Thank you. Forge ahead.
Thank you very much.
Yeah, thank you. Next item.
Item number 8, file number 17075, has been withdrawn by the complainant via fax.
Okay.
Next on the agenda, item number 9, file number 17092, complaint filed by Ellen Sang against John Ram and Brash and the Planning Department for allegedly violating Administrative Code, Section 67.21 and 67.25 by failing to respond to an immediate disclosure request in a timely and complete manner.
Compliance and amendments.
Compliance amendments.
Yeah.
Go ahead,
Okay,
Member
so
Kanata.
this was a case where the complainant had asked for records from the planning department and did not get a response for a long time. Eventually got the records. The planning department and Ms. Silva have agreed that there was a violation in providing these records. At that time, planning had some issues. The one that was just withdrawn, the planning had issues with their process in responding timely, and they've, according to Ms. Silva, those issues have been taken care of, and that's where we're at with this.
Okay. Complainant?
Yes.
5 minutes.
Hi, complaining Ellen Sang. I make the IDR on August the 16th this year, was Wednesday, and for 2 documents, is for plan, basement level plan and first floor plans. And on the August 17th, no response for planning and the respondents. On the 23rd, I sent them an email, remind them I did not receive a response. Nothing from them. After I filed Sunshine, and the Sunshine policies require them to submit a written response, but they ignored it. They did not submit anything. A few days before the compliance amendment committee, and they, Mr. Silver provided, I think, the note or a letter to the to your department, I mean, Sunshine, and then at the hearing, he calmly and willfully and stated that his statement is for this complaint, and then say that on the Thursday, August 10, the department received my immediate disclosure for me. It's for the public record, those things, and then they said they comply. And then they attach to something. They know that, he knows that my Sunshine request is for 2 documents. The August 10th Sunshine request is for 5 different documents. And he's still calmly and forcefully tell you, they want you, under this complaint, consider both Sunshine requests and vote on it, and intended to take away my right to file another Sunshine against them for the non-response and untimely Sunshine request on my August 10th request. Yes, I thanked for the committee, and after they ordered the respondents, they did provide 2 pieces of the plans. But I asked him to issue the order, one for not timely respond, and they actually intentionally, the way they act is just like, you have Sunshine request, I just don't respond. Even though worse, when you file the public file Sunshine complaint like me, and then they don't, as the policies ask them to submit the written response, they just ignore that. And then they intentionally and then added another my sunshine immediate request for different day for different document and put it into under this complaint and want you to vote on that and wanted to take away my right to file another one for different document. I ask you to issue the violation and also state that they are in violating of the sunshine policy by refuse to provide the response to the complaint, and also at my other sunshine request not related to this sunshine request, to this complaint, and then I want you to state my right to file another sunshine complaint for different document on different day as I preserve. So in other words, I should have the right to do that. So in other words, you are not voting for my 2 sunshine complaint, okay? It's only for one, which is August 16, for 2 documents. They try to add on their own without my consent, without my agreement. And that should be clear. That cannot be allowed. Thank you.
Okay, thank you. Are there any persons or witnesses providing facts or evidence on behalf of the complainant, the petitioner? Seeing none, respondent? Please state your name for the record.
Good evening, Christine Silva, planning staff. When we originally received this complaint, we misread the complaint. We were handling several requests from Ms. Zhang at the same time, and so there were a lot of overlapping requests and productions. And so we misunderstood that to be an August 10th request instead of the August 16th request, which is the actual request. So as directed by the Compliance and Amendments Committee at its September 19th meeting, staff researched the August 16th request, which is what the complaint is regarding, and could not find a response to that request. The following day, Wednesday, September 20th, staff produced the requested records via email attachment, which is page 126 of your packet. At this time, all responsive records have been provided to the requester. The department acknowledges that we exceeded the original window of time to respond per admin codes 67.21 and 67.25. Happy to answer any questions.
Thank you. Any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none, members? Member Canada?
I would just, if there's no discussion, I'll make a motion, but...
Let's get through rebuttals, and then we'll
okay.
deal with that. Are any other questions or comments, any clarifications?
Just the one comment
Sure.
that, to Ms. Tsang's point, that this is only for the one IDR, Ms. Tsang, right? This is for this is for the 16th. If you have issues with any other IDRs or requests you have made, you definitely can bring complaints. That's
I just wanted to make sure, because of planning, know how to manipulate the situation, and next time they say, oh, we've already heard you, we have the documents that meet that it was heard, and that's what, as a public member, we know they would, most likely they would do that. So I wanted to know my right is preserved, and also the way they respond, not responding even to the sunshine policy too.
No, he's asking her a question. Go ahead. Go ahead. Finish.
Okay. What do I say now? Yeah.
That's so the question was basically I wanted to let you know that you can bring other
thank you.
Complaints.
And also, I think that you should note and then put it in the order. You are not supporting the ad. They are just ignoring your policy. When the complaints filed, they have to give a written response to sunshine complaint. You can see how hard it is. Even you have policy, ask them to give a written response to the sunshine complaint. They ignore that, not responding. How many taxpayer paying the salary? What do they do every day? I don't understand that. Maybe they have too much budget, and so they can afford it to come here. For defend them not produce document for whatever the reason they can have. Thank you.
Ms. Sang?
Yes.
So I'm looking at page 115, and I see a memo from the Planning Department to our administrator dated September 11th.
Yeah, that one.
Yeah.
They submitted to your department. I get when I get the hearing, then I saw that. But that one has nothing to do with my 16th complaint. They actually addresses for the 10th.
Yeah, I understand that,
Yeah.
but I think it's one thing for them not to respond at all. It's another thing to respond on something unrelated or by mistake. Okay, so we can't just say they didn't respond. They made a statement that they made a mistake. They misunderstood for which IDR it was for, right?
If you believe them, yes, but I don't.
Well, I can only go by what's presented.
I know.
We can't put people under oath here,
Yeah,
okay?
I know.
So we've got to take them at their
Yeah.
word at this point. But be it as it may, I mean, if your complaint is that they didn't provide a response to the Sunshine Task Force, I find it hard because I see a document here.
Okay, let me explain then. When you file the Sunshine complaint issued the letter, tell them, hey, there's a Sunshine complaint file. You have, I think, the 15 days to provide the written response. Not, before the hearing. That's many days, probably months after. But maybe Victor can clarify.
When was notice sent to the Planning Commission for this one? By the Planning Department for this one?
I don't have that document with me, but I would assume it would be close to the date of filing, which would be the August 23rd date. However, even though we do request that the respondents respond to my notice of complaint filing within 5 business days, there is no requirement that they do that. It is a request, but there's no official written requirement that they must respond within 5 days.
I believe the letter says that you are required, but obviously by that's usually they says that you are required to provide written responses, and then have a listing what they should do actually.
Yeah. Okay. One moment.
Thank you.
So according to our procedure, upon receipt of the complainant shall be given a summary of the complaint procedure. The responding city, department, or agency, the respondent, shall be sent a written notice of the complaint with a request to respond to charges in the complaint within 5 business days. Failure to respond to an SOT, to Sunshine Ordinance Task Force complaint, and or failure to provide requested documents may lead to a finding of violation of Sunshine Ordinance. That's our procedure.
Yeah, that's what I was talking about. I think the usage is...
Yeah, but the thing is the request is within 5 days, okay? It's not a requirement. The requirement is that they got to submit something.
Yeah, but they didn't. But they
submitted there's a document, but there's a document right here.
Yeah, that's a September 11. That's many days after the August
28th?
24. Yeah, they
August 24th, and then you had Labor Day, so you had a long weekend.
Okay, whatever.
And
they did not even say that.
And this says September 11th, but even still, if a request is for 5 days, it's not a requirement, okay? But there's a requirement to send something. They did send something.
Okay.
Okay, I don't think we can quibble about a few days here and there.
Okay.
If
the hearing was not ordered them, I don't think they would ever give to me. But I thank you for your time and effort to make them order them to provide. There's a 2 pages document they did provide, yes, after the order.
Okay.
All right, but there's some other issues I think that's equally important as the member public. It's hard already file the complaint and then attending the hearing and expect them to follow the rules. Thank you.
Okay, thank you. All right, rebuttals, ready? Okay, respondent, any rebuttal? No? Ms. Sang, do you have any additional rebuttal? No. Okay, thank you. Is there a motion?
I move to find violation of 6721 and 6725 for not providing information in a timely fashion and not providing information until we told them to do it.
Second.
Moved by Member Canada,
Can
second
I
by
add that
Member-
it is for the August 16th request?
Right, just for, exactly.
Yeah, for the August.
It's the until we told them to do it isn't actually part of the motion,
Okay,
correct?
right, take that out of the
Okay.
motion, thank you.
This is for finding of a violation of 67.21 and 67.25 for failing to respond to the public records request in a timely manner is my understanding.
Yes.
Correct. Moved by Member Canada, second by Member Hinsey. Any other discussion, Member Moss?
Yeah, I just so I understand, is 6721 and 6725 both necessary in this regard, or?
It was
I
an
just wanted-
IDR.
It was an IDR, and they didn't get back to them.
You know, essentially, 6725 is a kind of an extension for immediacy of 6721. Okay, so it's kind of like that, even though, and you just have to follow the specific provisions within 6725. So if they didn't respond at all, or if they didn't provide full documentation or anything like that, it's pretty much covered under 6721. 6725 is just an extension to provide immediacy, more or less. But it's okay. I think either way it works out in the end. It's all part and parcel of the same language. Okay, any public comment? Seeing no public comment, please call roll.
On that motion, Member Canada.
Aye.
Canada, aye. Member Hensy.
Aye.
Hensy, aye. Member Josh Wolf.
Aye.
Wolf, aye. Member Eldon, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Fisher.
Aye.
Fisher, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, let's call the next item.
I believe that the complainant has agreed to have the next three items called and heard together.
Okay, is there any objection to combining the next three items? Seeing no objection,
This is item number 10, 11, and 12, file number 17079, complaint filed by Mary Miles against Mike Salaberry, San Francisco Municipal Transportation, for alleged violating Administrative Code Section 67.25. File number 17080, complaint filed by Mary Miles against Will Tabajanda against San Francisco Municipal Transportation Agencies for alleged violating Sunshine Ordinance Section 67.25. And file number 17081, complaint filed by Mary Miles against Luis Montoya, San Francisco Municipal Transportation Agency for alleged violating Administrative Code Section 67.25.
okay, this,
was an EOTC case.
okay, would you like to
Sure.
present?
So this case was interesting in that we had three separate cases, three separate file numbers that were, in essence, very similar requests to different individuals within the same department. And so each complaint was filed against each individual because although eventually there was a response provided by Carolyn Salea that was representing each of those individuals who this complaint is against have not really actually responded to the complaint. We did receive a document passed around just a few moments ago that does in some way have a response from each of these people pertaining to the complaint, but it does not look like these emails were directed to the initial requester. So the initial requester still, to the best of my knowledge, has not received a response from the named individuals, although the documents have been addressed in regards to the SFMTA.
Just a question, point of information, is this an IDR?
It was an IDR, yes.
All three?
Yes.
Oh, yes, they are. It's noted. Okay, thank you. All right, complainant, 5 minutes.
Thank you. Mary Miles. First of all, I strenuously object to whatever you have in your hands. It wasn't presented to me. I have no way to rebut it. I haven't even seen it. So I would ask you to completely disregard it, whatever it may be.
If we can you halt time for a second? Just a point of procedure here. We're not to receive documentation that is pertinent to the case at the case. That's pretty much our rule.
I believe the rule is that I'm allowed to provide it to you, and it's up to you to determine whether or not you will take it into consideration.
I was under the impression that that documentation. I'll dig up the provision, but I pretty strongly think that we have a provision that parties cannot present documents at the hearing that are pertinent to the case, that we would have had to receive them within a certain period of time.
We do request that they provide it 5 business days before the meeting, but it's at the discretion of the body whether or not to accept it.
Yeah, I thought it was.
It would be in the complaint procedures.
Just a moment. We'll restart your time. That's why I want to stop it. Ensure STF will remove. Okay, to ensure STF is able to review documentation prior to the meeting, is requested supporting documentation to be provided at least 5 working days prior to the hearing to both the task force and to the opposing party. Any documents or other evidence provided less than 5 days prior to the meeting may not be reviewed or may not be allowed as evidence. That's pretty definitive. Any documents or other evidence provided less than 5 days prior to the meeting may not be reviewed or may not be allowed. That's not the request is one thing, but the presentation is another. And then it goes on to say, if documents are provided less than 5 working days prior to the hearing, the complaint hearing may be continued unless the opposing party agrees to allow the late acceptance of new evidence. The task force reserves the right to determine if any late submissions of documents will have an impact on the complaint hearings and take action as needed. So I will leave it up to members to determine the disposition of this document that was just handed out.
Through the chair, just hearing you read that may not is not the same as will not, and it sounds like it's up to us to determine. But I think the fact that the complainant is already objecting is grounds enough to disregard this.
Member Moss.
I mean, the only thing I would point out is that it seems like this document is in response to a request from the EOTC.
Is that correct?
Yeah, that is correct to some degree. I never specifically requested this document be created, but in essence, there was a question as to whether these 3 individuals were in possession of any documents, and this answers that question, which had been floating at the end of the previous committee hearing.
Either way, it doesn't discount the fact that the opposing party, it was not afforded an opportunity to see it. And if there's anything substantial in it, may have changed the course of her presentation.
Yeah, looking at the date with Victor receiving this, that may be on us for not providing it to her yesterday.
That would still exceed the 5 days.
Right.
Right, but I mean, it is. I think that if.
But it's up to us whether to determine whether or not we received. I mean, this is.
So I don't think this email has any bearing on whether or not a violation occurred. However, outside of the violation, it does have some indication as to whether or not there is still more information out there that the complainant has not received.
Member testify.
Has the petitioner been provided with a copy of this email so she can?
No, she just testified.
No,
Yeah, I mean, I
never
know.
heard
I
about
mean, right
the
now.
emails.
I meant right now.
Yeah, it's too late with too little.
Not to be
object
used
to
now,
this.
but for Member Wolf to say it has no bearing on this or that or what's going on, if she hasn't even seen it, I don't know how she can.
Well, the question is
Then-
whether these documents will have an impact on the hearing or not. And it's up to us to determine that.
It is, but I think that she could make a statement whether she thinks that it would have bearing on.
Okay. Also, our provisions say that we must take action
Okay.
on this, whether to accept it or not. Yeah, it says the task force reserves the right to determine if any late submission of documents will have an impact on the complaint hearing and take action as needed. So I'm going to leave it up to you guys how you want to dispense with this.
Sure. Could
Vice Chair Howland.
we give the petitioner a chance to read it, make a statement, and then make a ruling?
I think she's already made a statement that she
It's already been pretty clear.
objects to the document because she hasn't had an opportunity. I don't know how much longer. It's almost 9 o'clock already. I mean, I don't know if she wants to. If it has some impactful adjustment, she might ask to be continued. But she's been also sitting here for 5 hours. So
Maybe we could ask. Can we ask her through the chair
go ahead.
how she feels?
Yep. Member testify. Go ahead.
First of all, if this were a court, it would just be summarily tossed out. You have to serve the opposite side with whatever you're presenting to the court. I realize our procedures here are different, but I think it's grossly unfair to present me with something and tell me to read this,
Would you prefer that we continue the item through the chair?
I'm sorry.
Would you prefer that we continue the item?
Why is that? Are you saying my options are read this or continue the item?
My question was, can you please speak to this item? Speak to what's going on and let us know what you think.
Speak to the items that are on the agenda?
Speak to the presentation of this
complaint.
document. Do you object to this document being
I already
presented?
have. I've
Yes, she
objected to
has.
presenting this document to me and to you 30 seconds, before the item is scheduled.
Because
no one could possibly assimilate this
Okay.
or
thank you.
develop an argument, and it's a sort of a due process issue.
Okay, thank you for articulating that.
Through the chair?
Yeah.
I think we just have to just reject it at this point. That would be
But we
my-
can't put what we've already read
I have
back
not read the
in the
item.
can.
I have not read it, so.
Okay, so should I?
You can just disregard it. It's not part. It cannot be part of the decision making.
Discussion.
It's like telling a jury to disregard what the last statement that was said. Yes, you can put it back in the can.
You can do it, Josh. Just when you're trying to construct why you're coming to a decision, do not use this document as a reason why you are coming to a decision.
But this document is the answer to the question that was the sort of hanging point at the end of the
yeah,
committee.
but we have a
then you don't use it.
procedural issue.
Then you don't use it.
Yeah, we have a
still-
procedural issue, and the procedure allows the
No,
opposing
I
party.
understand that. What I'm trying to get at, though, is that basically our job as complaint committee is to ensure that all the pieces exist to clarify the situation. Without the answer to this question, it should have gone back to complaint committee.
Well, it's not the complaint committee, first of all. 'cause
Well,
I've
the
never.
committee that heard the complaint.
Whatever
The committee
committee
that
is
heard the
the complaint
complaint,
committee
okay.
has been the language that had been used previously.
So here's the thing. If a party feels that this document or any other documents would change the outcome, if these documents were not included, they can always reconsider it.
No, I understand that. That's all well and good. I'm just trying to state that, my responsibility as chair of my committee was to ensure that all the pieces, all the information that was necessary was there.
Yes. And if it wasn't there at the time that this hearing came up, then it either doesn't exist or it came late. And under our procedures, it's very clear on the process. for either including it or rejecting it.
That's not.
Through the
yes,
chair.
I understand that. That's not the point I'm trying to make. All I'm trying to say is that to the extent that the file is incomplete without this, it's incomplete without this. That's
okay.
True. So what I was going to say to that
Yeah.
point, if the answer to that question comes out during the two parties talking, then I think that's something that's okay because it's being presented to us formally and the respondent and the petitioner all at the same time. And that's where I'm hoping we're going to end up with. If this, whatever this information comes out in that fashion.
That's fine.
Right. We should be okay. Right.
I disagree that the file was incomplete because the file was approved at a vote as what it was, and that means the file was complete and sent to us.
But no, I'm saying that my responsibility as directed for being the chair is to only to bring the file forward if we have all of the missing information figured out. At the end of the hearing, it was, this needs to get figured out in order for it to move forward. Now, I didn't anticipate this to get figured out outside of the timeline, but to whatever extent the file's incomplete because this is missing is because this didn't get into
I understand. No, I do not hold you responsible for producing an incomplete file. You did your best to try and complete the file. Whatever was presented was presented. If one or the other parties did not provide all the information, even if requested, that is what's presented to us here. If they are not satisfied with our order of determination, if a violation is found or not found, one or the other parties can, within 10 days, file for reconsideration and then bring additional information that might compel us to make a different decision. That's the whole purpose of it. So I understand it. As chair, I am not holding you responsible for an incomplete file. We consider it to be complete. It's a responsibility of the parties to provide any additional evidence if they chose not to provide any evidence at all. And right now, that's what we're considering, that there's no additional evidence.
Okay.
Okay? All right, so let's move ahead. Start the clock again.
Thank you.
Wait, so are we disregarding this or not?
Disregarding
The file
this.
is complete as he had sent it to us, yeah.
Can I just return this so it's not sitting?
I'll come and collect them.
Thanks.
Thank you. I think on its face, the complaint is pretty simple.
Have you started the clock?
Yes.
Thank you. Go ahead. Please proceed.
That is, I requested in an IDR, very similar IDRs, information from 4 separate employees of the MTA. I got an answer from only one of them, and that was through Ms. Celaya, who sent emails of Ms. Wong, who was one of the 4 employees to whom the IDRs were addressed. And after that point, I asked again, where are the other 3 from Salisbury, Tabajanda, I'm sorry if I'm doing violence to his name, or Mr. Montoya. Those were never received and still have not been received. There's no debate that I know about from MTA about the fact that they have not been received. MTA has instead taken a legal stance that it is not obligated to provide the records of its employees. Excuse me. I have submitted a 3-page brief to the committee, which is in your file, beginning at page 137. And within that brief, I say exactly why MTA is completely wrong. The California Supreme Court has spoken to this issue just this year in the City of San Jose versus Superior Court case, which is, if you need a cite, I can get that for you. It's 2017 2 Cal 5th 608. It is explained on pages 2 and 3 of my brief. And in that decision from the California Supreme Court, it definitively stated and explained that the staff of any agency must disclose their records, even if the staff keeps them on a private computer, an iPad, anything. They are obligated, and the agency has a duty to produce them. So that is why MTA is wrong here, and that is why MTA does need to update its process. If it's spurious to say, it's just not valid to me to say, you ask the same questions of these 4 employees, only one needs answer. Each employee may have different emails, different records, and whether they do or whether they don't, I am entitled to ask for them, and the city agency is obligated to provide them for each of those employees. And that about sums up my argument, and I except to conclude that I haven't received them. I've received nothing from Mr. Montoya, Mr. Salaberry, and Mr. Tabajanda. So I think it's a legal issue. It's I don't think there's the facts are in dispute here.
Are you finished?
Thank you.
Okay, thank you. Are there any persons or witnesses who provide any facts or evidence on behalf of the complainant, petitioner? Seeing none, a respondent, you have 5 minutes.
Hi, I'm Caroline Celaya, Manager of Public Records for the SFMTA. The SFMTA has responded on behalf of the employees. I am the manager, and I am the only person responsible for responding to public records request. When the request was received by staff, the various staff, I entered the request into our online database system. That's our normal procedure. Ms. Miles chooses not to use that system, which is fine. She doesn't have to. But internally, we use it so that we can continue to track the request. The request was given to the division designee that handles where all of these employees are in, Sustainable Streets Division. That person then asked each of those employees whether or not they had responsive documents. Only one person came back and said they had the responsive documents. That person provided the documents, and I forwarded them on to the requester as her preference via email, not through our online system. And so we did provide a response to the request. The request was not similar, but the same exact request. I checked it. So it wasn't different requests to different people. It was the same request to 4 different staff persons. My concern here is that I don't want to have to tell staff people that they have to respond individually, because that sets a poor precedent. That's my job. That's what I have to do. If everyone starts sending out different documents, we lose track of everything. We have a system in place so that we can indeed track exactly what our agency is sending out to the public in response to their request. So that is why you're not seeing those 3 individuals. I, as the manager, am responsible on behalf of the entire agency. My letter, my email to Ms. Miles indicates that in the very first sentence. On behalf of the SFMTA, I am responsible. I am sending you the responsive documents. We do not have our staff members individually respond to requests. That would create chaos, and that's not our procedure, and staff is very well aware of that. They know to send it directly to me so that I can respond. As to the document that you were provided, that was only done because during the committee meeting, I don't recall, but one of the members of the committee suggested it. They merely suggested, what if each of these people signed something or wrote and said that they did indeed check their files and that they didn't have anything. Ms. Miles at that time said that would not suffice for her. I took that conversation back to my supervisor, who said, let's put it together anyway, because the committee made the suggestion. So I apologize that it was late, but we went forward with it at the suggestion, not the mandatory. It wasn't, you guys need to do this. It was suggested. And because we appreciate your suggestions, we went ahead and went forward with it. And again, I do apologize that it was late. And I'm happy to answer any questions. I don't have anything further.
Any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none, members? So I have a question, Ms. Zelaya. So under the ordinance, under 6721, which it's kind of the basis for making a request, and IDR just is an allowance to speed it up. But under the basis of responding to a request, the very first sentence of this section really speaks to the heart of this matter. Every person having custody of any public record of public information shall, at normal times and during normal and reasonable hours of operation, without unreasonable delay and without requiring an appointment, permit the public record or any segregable portion of the record to be inspected and examined by any person, and shall furnish one copy upon payment of reasonable charge, not to exceed the lesser of the cost, so on and so forth. Okay? So when a person is being asked, an employee, a public official, elected official, is asked specifically by name to produce a document, it's their responsibility, not anyone else's. Not a representative, not a public information officer, not somebody in the office that handles public information requests. The only time a representative comes into play is what you're doing right now. Is you're allowed to come on behalf of custodians at a hearing. But the responsibility for production of public information is solely on the person who's being asked for. Alternatively, if somebody made a request to a department in general, okay, that's a whole different ball of wax. Then your job as being the public information officer or the person that handles requests on behalf of the entire department, that comes into play. Okay, so that's the distinction here. In this case, we have 3 complaints against 3 individual people, of which requests were made to them by name. So that's the first part. Okay. The second part is why they didn't respond. So I don't know if you quite explained that in your opening
They did
statement.
respond.
But did they respond to?
That's not our internal procedure. So no, they did not respond directly to the requester. That's not our procedure.
Okay.
That's not our internal policy.
Okay. So you
They responded within our database.
Okay, but you
Within our
understand that your policy is not in compliance with the ordinance.
That's not what our city attorney has told us. So it's unfortunate you don't have a city attorney tonight. That's been a problem all evening, as I've noticed. But our city attorney says that neither the California Public Records Act nor the Sunshine Ordinance obligated individual employee to personally respond to public requests or authorize the requester to dictate who must respond to a particular request.
And in
That's
what
our city attorney.
but where cites your responsibility as a respondent is to cite the law that would.
The obligation is to respond is placed on the agency in possession of the record.
Cite the law. Cite
67.21B.
A custodian of public records shall, as soon as possible, within 10 days following receipt of requests for inspection or copy of a public record, comply with such request.
I'm the custodian. That's me. And I did.
No. You got to go back to the first paragraph. Every person having custody of a public record or public information is defined herein is a custodian of the public record. So if a person is asking another person, 6721A.
Where does it say that every person having custody of any public record is
The
a
very
custodian?
first word, 6721A. Every person having custody of a public record or public information, as defined hereinafter referred to as a custodian of a public record. That's the person that has custody of the record.
But does it say that that person has to respond directly to the requester?
Go to the second. This is process. Okay. So, well, it does. It says, shall at normal times and during normal and reasonable hours of operation, without unreasonable delay and without requiring an appointment, permit the public record or any segregable portion of the record to be inspected and examined by any person.
No, but does it say that they need to personally respond? That they need to permit them to do that, but does it say that they can't do that through a designated individual in the office? Like if someone sent an email to the mayor asking for a record, would the mayor have to personally respond with the record?
Yes, because the ordinance specifies an authorized representative.
That's who I am.
Isn't she the authorized representative? Just because we've never had...
But only under Section E with regards to showing up at a hearing.
My concern here is that we've never had, when a request has been put into a mayor or a board of supervisor, we've never required that person be the person to respond. We've always allowed the custodian of records for their office, their chief of staff, something like that, to respond. So,
and in history, we've had contention with that they don't show up. And they do send, but they can send a representative here.
That's not what I meant about showing up. We've never said that they have to have, like if the request was put into the mayor, we've never said that the mayor has to be the person to personally respond to the request.
Yes, absolutely. Absolutely. Unless it's sent to the office of the mayor or the planning department in toto or, a specific agency. We absolutely have been, I see your hand. So we absolutely have requested, when that requests that are made to specific people, those people either, if they have the record, they must produce it. If they don't have the record, it tells you what to do right here in the audience.
I guess
that they must assist them in finding the record.
I always think of the cases that Ms. Trabou brings up that she sends to Ms. Trabou, that she sends to various people at the Arts Commission. Howard Lazar, I believe, is one of them. There's another person, I can't remember her name, but it's a woman, not Kate Patterson Murphy, and we've never required those people to respond personally to her.
Absolutely. There have been violations against them for not showing up or not actually acting.
Not showing up, but when Kate, we'll just let this go, but this is where there's going to be a point of disagreement for me. So I want everyone to be able to go forward.
All right. Member Josh Wolf, Member Moss, and Member Kanata.
So this was I don't know whether everyone has these notes, but if you look at these notes, there's this highlighted section that, during the committee, we were kind of not sure how to navigate this. So we had sought out the City Attorney Cola's perspective on this issue to try to provide some clarity. I don't know whether the city attorney had an opportunity to respond in a written form before not showing up, in which case it'd be good to know that, because this really is sort of a legal issue that at least the committee felt overwhelmed navigating without Cola there at the time. So I guess the first question is, did Cola somehow respond in writing to this question that we have?
I don't recall receiving a response.
Okay.
Member Moss?
So I don't agree with Chair Wolf's position on this. I think that if that was the position we had, we would have found a lot more violations on essentially every case that we've ever heard here in which somebody has sent something to the mayor's general email, or a city council member, or just random employees, or walked up to somebody at the library and asked for a piece of information, and then somebody who is a professional at handling public records got back to them. But so I don't feel like that's the case. I don't think that's how the California Public Record Act works. I also think that I could file a sunshine request and get the 27,000 emails of San Francisco employees, and I could write a script that would bring the city to a standstill by by simply filing public records request and requiring every single person to respond to the same request, and then violating, tens of thousands of employees all at once. Like, that's just not how the Sunshine Ordinance should work.
Member Josh Wolf and Member Canado.
For the
Okay,
respondent,
Member Canado,
I'm
sorry.
looking at page 153. This is an email you sent to Ms. Miles saying that all the records include, I'm sorry.
Sorry.
153.
Were you speaking to?
No, to you.
Oh, okay. I'm sorry. Go ahead. I'm on that page.
Okay, so this is an email that you sent to Ms. Miles, and this
Yes.
is the response. Now, she sent an IDR to 4 individuals, and you're responding for all 4, is what you're saying?
Yes, that's correct.
Well, I'm looking at this where it says, attached after the document production, you list below is the name and contact info for the staff that responded, and you only have Ms. Wong down. So by reading this, did the other 3 not respond to you?
I see what you're saying. I read it as responding with documents, and she was the only person that had documents, so she was the only one that responded with documents. So I see where it would appear that others weren't asked when that's not the case. We really did ask.
It's confusing to me because you go on to say that you determined that there are no other records from those other 3 people. So their names to me could have clarified this much better.
I see what you're saying. I agree. That does make sense. If I had said that, well, I mean, it's implied that the NCSMTA determined that there's no other records. This means other people were asked, not just Ms. Wong. But it could have been made more clear. But that is indeed the case. Others were asked, and they did not have any documents.
Okay.
Yeah.
So I just want to clarify something here, okay? This task force, for many, many, many years, has found custodians, actual people, in violation for being unresponsive, for being asked for documents and not being responsive at all. It's also found a violation of people who have been asked for documents that did not have the documents and then did not assist people at all in regards to 6721. There's no intermediary. That was the way it was written. It was written for the person who has the document in hand. And that person, it's a one-to-one communication between them and the requester. The only alternative is if they make a request to a department or to an office, like the city attorney's office. There's no one person, okay? Lots of times the mayor, if they send it to the mayor's general email, or to any other elected official, to their general email, they will consider that to be the office of that person. That's the way they consider it, okay? Now, when you have when you have like the Board of Supervisors, it's a little bit easier because it's just 3 people that are aides in that office. It's really meant for the supervisor themselves. If they send it and address it to Assessor Carmen Chu, they address it to her by name, that's different than saying the office of the assessor. So that's how it was written, and that is how the framers intended it to be. I wish Rick Nee was still here because he would vehemently argue in support of what I'm saying. Yes, ma'am.
There is another alternative that you did not mention. So if someone receives a request, an individual, and they do not alert the custodian of records in the office or someone else that has responsibilities in this area, or they do alert them and then that custodian of records does not respond, then I can see holding that person responsible and a violation. But in this circumstance, these individuals were contacted. They contacted the person with that responsibility in the office, and that person in the office responded on their behalf. And so that is, and the California Public Records Act, that is absolutely not the interpretation in the California Public Records Act. We can say, if others on here want to say the Sunshine Ordinance says something different, which I disagree, that's fine. But the California Public Records Act does not require the individual who has responded to provide the response. They require a response to come from the agency, but it's not the individual that received the email. That individual can send the request to the person with that's been delegated with that responsibility at the agency for the agency to respond. If the individual who did receive the request fails to send that to the responsible person at the agency and no response is ever sent, that individual can be held responsible.
So there's nothing in the ordinance that requires the department to have a global custodian of records. So there's nobody for a custodian to contact. Okay? It's exactly the purpose of this section was to direct the particular person who has the document. The CPRA allows for an extension to provide more transparency and more expediency of public records delivery and allows local agencies to create, to extend or create more transparency and expediency, which is what the City and County of San Francisco did by creating the Sunshine Ordinance. So thus, this trumps the CPRA. It's one of the few kinds of laws where it allows the city to provide more action. I know it's not the right word. It's like more authority in a way to provide and in this case provide the delivery of those records. I mean, that's why this is the most powerful. We have one of the more powerful laws in the country because of that. The state gives us that extension. Okay, this was written, and I could drag everybody that was on the task force from the beginning in here to tell you. They will tell you that this was written with the intention that each individual employee, and yes, Member Moss, you can do that and bring the city to its knees, and it happens in the planning department quite a bit. There's a tremendous amount, and if you look at then Supervisor Wiener's study, he actually did a financial study on the cost of Sunshine to the city government. It wasn't a whole lot of money. It came out to be a little over $1 million or so. Okay, but the response from people was that it takes up at least 20% of their time in employment. Mm-hmm. Yes.
So you're saying if I file an IDR right now with you for all of the orders of determination that this task force has ever done, you have to sit here and let me examine it and not Victor?
That's right. Unless I say I'm not in possession of them. But I will.
But nobody's in possession of them.
That's right. But I will assist you as to where you can find them. That is how the law is written.
All right. Well, then, if that's the case, so she's already testified that the three people were not in possession of the custody of these documents. So
But the question is did they relay that information directly to the requester?
I do not think the ordinance is saying that you can't have an agent act on your behalf.
It does, because in 6721E, in the last sentence, that is the only place where it talks about somebody other than the custodian.
Through the chair?
Yes.
I can see myself on both sides of this debate, but there's a complaint against 3 people in this department who didn't individually respond, but the fourth person, Ms. Wong, didn't individually respond either. Ms. Wong's response came from the respondent.
But she's not even listed as a complainant.
Right.
Oh, yeah.
She's not, because she got an IDR, and her response was done through the respondent, not individually by Ms. Wong. So there is no complaint against that, right, that it didn't come from the individual. So that's why I said both sides of the debate.
But that's exactly how the requester is reading the Sunshine Ordinance. She experienced a custodian of record that directly communicated with her, and the other 3 did not. They communicated through
directly communicated, indirectly.
Oh, indirect. I thought you just said that she directly.
No, she indirectly communicated, and if And again,
but she's not part of this, so
no,
I don't.
But I'm trying to get this argument about it has to come from the person requested. We're here, it didn't come from the person requested, and there's no issue.
But just because the complainant didn't file a complaint against Ms. Wong doesn't somehow mean that that one was proper. Like
I'm not saying
she
that.
could add the complaint against Ms. Wong, and then we just have 4 complaints to deal with.
I'm not saying that. I'm trying to make the point that this highlighted area that we needed DCA COLA to look into this and give us some input would have been very helpful.
Yes.
Because if all 4 people were named in this document, okay, Ms. Miles,
What
I have a
difference
question for
would
you.
have it made?
That's the question. If the response we're looking at on page 153 that has Ms. Wong,
Yes.
that has these are the records we have, and the person below the name and contact info, the staff that responded, Jennifer Wong.
Well,
if
the subject line says Jen Wong's emails.
But it's not from Jen, right? This is Jen, the subject line, response to immediately disclosure request. If this document had all 4 names there under who responded, would that have made a difference in you putting in a complaint?
No, they would have had to respond with their records, regardless of whether that response was made through Ms. Celaya or by themselves. They had to respond to my request to them.
Okay.
Here's another deal that I'm sorry to interrupt, but in saying, "Oh, this is the only response," just look at page 175, and you'll see that Mr. Tabajanda himself must have gotten a CC from Ms. Wong of some of this stuff. And there was a reason for the request to begin with. And the reason why I requested it from those individuals, because they were very involved with that particular project. So I'm sorry that I interrupted you.
No, that's quite all right.
But I have a question for you, Member Kanata. If you look on page 154, which was Ms. Miles' original IDR request, and you look at the header at the top, it doesn't even include Ms. Wong. I don't understand why she's of any topic of discussion in here. Page 154.
Right, there were 4 similar things. One, the others to Montoya and to Salaberry were very similar to what went to.
Yeah, I don't see that there's any requests from Ms. Miles to Ms. Wong. Ms. Wong's.
That's the one that got a response.
Yes.
That's the one that didn't trigger a complaint.
Right, there's no complaint against Ms. Wong.
I see. Okay.
The complaints are against those other 3 people.
My misunderstanding. Okay.
Thank you.
But I agree with Chair Wolf completely in his interpretation, and I don't agree that the state CPRA has nothing about this, because as I just cited to you, that Supreme Court case is all about the CPRA. It's not about, particularly about Sunshine, although I agree that the CPRA does empower a local jurisdiction to develop its own stronger rules than the CPRA.
I have a question for the complainant. So let's say that you had gotten 4 responses back, and let's just say that like everyone had secretaries for some reason in this department, and you got a letter back from the secretary for Mr. Tabahanda. You got another letter back from Mr. Salaberry's secretary, and you got yet another letter back from whoever the Montoya's secretary. If you had 3 letters, none of which were from the actual named individuals, but from representatives of them, like their secretary or even their boss, I don't know whether it matters either way, would that have still triggered a complaint, or would that have been acceptable?
Well, I think you're dancing around the issue here. It's somewhat irrelevant if they funnel their response through their secretary. The question is, are they responding at all? And I didn't get a response from Salisbury, Tabajondo, or Montoya in any way, shape, or fashion. And they were involved in that project. Now, that's why I say it's a little bit tangential to ask me if their agent could answer. For example, I've done IDRs to the Board of Supervisors, asked each one for their calendar for last month. Maybe that was answered by a staff person, but I got those calendars. And it would be addressed to the individual supervisor. And it's the public's right to do so. You can do that to the mayor, too. If I want to see his calendar, I address it to him, not to the office of the, it's not but the bottom line is the public has the right. Each person who works for an agency is a custodian of the records both under 67.21 and under the court interpretations case law. I'm sorry. So it's a bit beside the point if they have their secretary to do it.
To the chair.
It's whether they respond at all.
Thank you.
That's how I feel about it.
Vice Chairman.
So if the initial response from Ms. Solaya had been written more clearly saying there was a response from Ms. Wong, here it is, the other three have no responsive documents,
well,
would that have satisfied?
No, she would have had to say, first of all, I'm not sure she said that. This is, I'm responding for everybody here.
Okay.
Well, let me look at this, but
I'm just trying
the bottom line is I made out these three requests, and I got no response to those particular three requests. If I'd asked,
So if she, let me ask it this way, if she then answered those three separately, in each case, say, person A has no response materials, second letter, person B has no response materials, third letter, would that have satisfied? It sounds like it would.
Well,
You're looking
perhaps
for,
if those individuals had responded in that fashion and said, I have no responsive materials, I could have taken it from there.
I think it's a little difficult for me to hear that, because if a person asked, the way I interpret the ordinance, I believe if every person who's a custodian has to respond on their own, okay? If the requester received a message from an intermediary and decided that that was enough for them, whether or not it was in violation of the ordinance or not, that's their decision whether to file a complaint or not. But if they felt strongly because they read the ordinance that there was a violation because they didn't respond directly to them, then that's what we're here for. And I think if there is such disagreement about the interpretation, then I would move for a continuance, and I'll wait till and instruct DCA COLA to provide advice on this, if not a written opinion, because his memorandum is not sufficient. To answer, I'm sorry. Go ahead, Member Jones.
So I like the idea of a continuance, but the one thing I do want to keep in mind to both our petitioner and complainant is that it does appear, as the complainant mentioned, that the facts are not in dispute. So I don't think that if we do move forward with a continuance, and I'm not sure everyone agrees with me, I don't think that we actually need to request the complainant and the petitioner come back to that to the follow-up meeting unless they want to, because I think this is really a dispute of how to interpret the law, not any facts in dispute. And so I just think asking you guys to come back wouldn't be necessary. That's my only thoughts. And continuance to get the city attorney's perspective on this, to me, would be very helpful.
Well, may I speak?
You can go ahead and respond, please.
Okay. If you're going to continue, I'd prefer that the that I be able to come back? I don't know.
Oh, you
how
would
to
always
respond
be
to-
able to come back. I'm just trying to get
Would we
it
be
out
able to
there that
speak
if
then?
you don't want to come back, we're not going to hold
Okay.
it. I would like us to not hold it against you. Obviously, we would need to
I see what
reach
you-
consensus on that.
Okay. I misunderstood.
You're always welcome here. It's a public meeting, and you're a party of the case, so you'd always have a room to speak up as well.
Okay. I'm sorry, I misunderstood.
I
Excuse me.
agree that I would feel more comfortable with the continuance and getting DCA COLA's legal input.
I'm just going to put out there that I will be missing the January meeting. So for everyone to know, I
Me
will
also.
be out of town hearings. So
Okay. All right, so shall we continue the item?
Someone
motion.
Make the motion?
Move that we continue this item.
Second.
Moved by Member Canada, second by Member Hensy. Any public comment? Seeing no public to comment, is there any concerns from either party about about continuing the item?
Would we have opportunity to speak to the
Absolutely.
item at the future?
Absolutely. We'll just pick it up from where we are right now in the middle of the discussion. We'll bring up whatever findings we get at that time. Our legal counsel will be here for that meeting, and we'll have that.
The second
So-
part of that motion was Member Josh Wolf's suggestion to make appearance at the next meeting voluntary. Would you like to consider that or not?
Do you want to?
I do not want to ask. I would love for them to come, but I do not want to ask our city employee to have to come back when she's already explained everything. That's my stance. If she wants to be here, great, but that's where I'm at.
Do you want?
Yes, I would like to include that in the motion.
I'll accept it.
Yeah, I will do.
That's simple enough.
Yes. The motion is continue the matter to the
can I
call of
make an
chair.
amendment? Can I ask a question?
Yes.
I just wanted to get a rough show of hands of how many people expect to be here at the January meeting. I just want to make sure if there's quorum or whatever. Okay.
Well, do we know this is going to January? That's the other question.
is it January
With
or
our
could it be-
schedules.
I guess it
Yeah.
is.
So that's January 3rd will be that meeting?
Right.
So show of hands of people who can make it or can't?
1, 2, 3. It does not appear favorable.
So we're not going to have a meeting in January.
Most likely.
So we'll have to call a
I remember
special
Eldon
meeting.
might be here. I don't know.
Yeah,
That's
but
still
it's still
only
not
6.
enough.
Okay.
Yeah.
Well,
because
Fiona, will you be here? She didn't raise her hand.
Yeah,
but she
I
might-
raised my hand.
Yeah.
Oh, you did? Okay,
1,
let's see.
2,
She
3,
got me.
4, 5. We'll have 6.
It's Wednesday the 3rd.
Mm-hmm.
Yeah. So we'll have 6, but frankly, I think we'll get a ton of more continuances because we'll only have 6 present. So
I will send out a poll and try to schedule a special for
special
January.
meeting. It'll probably have to be the following week or
Yes.
what have you. Okay.
So as part of the package, just a quick question, as part of the packet, will we be getting the written legal opinion of the
Yes.
city attorney? Fantastic.
Yes, absolutely. Yeah.
That's through the chair. What about the special meeting? Will it be in time for that? No.
We're packed. We're way too. That's why we're having it because we're
As you
packed.
probably noticed, there's a lot of missing items from today's
Yeah.
agenda that we pushed to the 19th.
Right. Okay. So can we take that by acclamation? The continuation. Okay. Seeing no
Matter will be
objection.
continued. Notice will be provided approximately 2 weeks before the meeting.
Are we talking January?
We are hopefully talking mid-January.
Okay.
We need to pick a special meeting date, and I need to pull the members.
Thank you very much.
Thank you.
Thank you.
Thank you for your patience.
Okay. Let's quickly get through the end.
The next item number 13, file number 17103, review and possible amendments to the bylaws and complaint procedures. The only one item that we have to take action on today, because I had to put out a 10-day notice to amend the bylaws, and that would be to bylaw section 10, hearing procedures for complaints. It currently states the task force and its committees must follow this procedure. We want to change it to only the task force being required to follow the meeting procedure, leaving the committee open to create their own process.
Or an agreed process that the task force creates.
Yes.
But all we're doing with right now is deleting those 3 words, correct?
That's right.
That is the suggestion.
Is it too soon to make a motion?
You go for it.
I'd like to make a motion to adopt the proposed amendments to the bylaws.
Can you just direct me to the page on that?
Page 403. Page, or it says 4 of 6, and it's section 10. And it's the first sentence. The task force and its committee shall hold hearings. We're seeking to strike and its committees.
Or the full task force, if you want to say.
It'll
only
just say
apply
the
to the
task
full
force.
task force.
That's all. There's only one task force. Okay. Let's call the.
Who's the second?
Second.
So moved by member Wolf, Josh Wolf, second by member Kanata. There is no public for public comment. Let's take this by roll call.
On that motion, member Josh Wolf?
Aye.
Wolf, aye. Member Kanata?
Aye.
Kanata, aye. Eldon, absent. Copra, absent. Member Tesfa?
Aye.
Tesfa, aye. Member Moss?
Aye.
Moss, aye. Member Fisher? Fisher, aye. Member Hinsey?
Aye.
Hinsey, aye. Vice Chair Hyland?
Aye.
Hyland, aye. Chair Wolf?
Aye.
Wolf, aye. The motion passes.
Okay, great.
May I suggest continuing this matter to the 19th?
The rest of them?
Yes.
The other two, so the reconsideration, this is the process for reconsideration and the process for rule of reason, which has been, we need to get to those at some point, so we should do them sooner or later. Luckily, they haven't come up before us too recently. Okay, call next item. Oh, chair's report.
The remainder of the items will be continued to the 19th.
The next. Well, no. We need to at least present the items in the chair's report. That it's.
Oh no, there's just 13.
Oh,
I'm only
13.
talking about
Yes.
13. The remainder of that item is continued to the 19th.
Right.
Okay.
Call
That
the
is
next item.
passed without objection on the continued.
Oh, yes. No problem with that.
Next on the agenda is item number 14, Sunshine Ordinance Task Force Chair's Report. We have two items. I will leave it to the chair to describe them.
So with the help and the insistence of and persistence of Member Moss in trying to get some answer with regards to the behest of payment in dealing with public officials, that was presented to us and passed by the Board of Supervisors. It was found by the Ethics Commission that the Sunshine Ordinance Task Force is not required to comply with the behest of payment. Yes.
Okay, so just some clarity on that. The process on this opinion is that the city attorney and the district attorney have 10 days from when they passed it to essentially veto the opinion, which is somewhere between Wednesday and Friday of next week, depending on how you calculate the 10 days. And I didn't look in whether they're counting the weekends or not. Technically, the opinion only applies to me, but it does raise the conclusion that the task force is not subject to the behested ordinance. But you just have to read it and make your own decisions based on that. Whereas if it passes, if the city attorney, the district attorney don't object to it, then I individually have immunity from prosecution under the behested ordinance. It's a little complicated. Apparently, the Ethics Commission has not dealt with one of these immunity opinions in a while.
Do you really think that's the way?
That is what they explained it to me. So if you read the thing, it's addressed to me, and it says that I have immunity from prosecution based on this opinion, as long as the facts don't specific to the facts of my situation. But you guys can read from it and take your interpretation from that.
So my discussion with Kyle, I don't remember his last name, at the Ethics Commission was that the entire Sunshine Task Force is removed from this.
That is the conclusion that the Ethics Commission raised, but the opinion, by nature of being what the opinion is in the opinion process, is that it is opinion specific to me in terms of the immunity issue.
But what about by association? You're a member of the task
Listen,
force.
like I
We're all
can't give you
members.
legal advice in this regard. I'm
Okay.
just expressing what the actual document says and what the process is.
But once your opinion is approved, anyone that's concerned can basically reference your opinion and ask for their copy of the opinion, which would then be applied to them.
That may be possible, but I am not your lawyer, so I can't
and I'm not
tell you
giving
that.
anyone legal advice because
Well,
I'm nobody's lawyer.
We'll ask. I'll put that on my list of things to ask DCA Cullen.
No, I mean they did reach the conclusion that this task force is not covered. That is what the document says, and if the city attorney, the district attorney agree, that is what it says. It's just that for whatever reason, like, just in the member testified might be able to help explain this a little bit better, but they've written an opinion that says, like, in terms of who like literally has immunity in case somebody wanted to try something later. I actually have a document saying I'm immune if it's.
It might just be like that type of document can only be written with the specificity of one person, an immunity decision, which makes a lot of sense.
Yeah, and I did not know I was asking for that until they had written it and given it to me. So,
okay, yeah, I think that it's pretty all inclusive.
Yeah,
but we will. If you feel more comfortable, Member Moss, we'll get DCA Cola to confirm it as our attorney.
Yeah, I just am not a lawyer. So
I hear you.
I
It's
can
all
only
good.
read what it says.
It's all good. But thank you for your persistence on this because it was on a lot of our minds.
And it may be short-lived because there's another ordinance that would include the task force that is moving its way through.
There's a whole nother huge thing that a lot of this is going to be amended, but that's going to go before the Board of Supervisors soon. If they rip it apart in such a way that the Ethics Commission doesn't like, they're going to put it on the ballot.
So how do you know that your immunity has been nullified, though?
They will let me know what the district attorney and the city attorney say next week.
No, I don't mean this week. I mean if they pass a new law that makes
no, it's because the way that it's written now applies to the current behested ordinance. The new behested ordinance is a different set of facts.
Yeah.
Oh, so passing of a new law automatically nullifies your ordinance?
Yeah, it would. I mean, the way the new one's written, like this one is just like the way it was phrased doesn't capture the task force in the end.
Right. The next one.
The next one absolutely would.
Okay, the next item I'm going to hand off to Member Moss also so he pick this up.
Okay,
and he's going to make a request.
So this was something I noted at the same committee that I was I just happened to be there for this for the opinion, but buried in the Ethics Commission packet. Do you all remember? I think we only had like 6 people here, but it was a packed house in here, and it was the Ethics Commission and whether they had properly taken emergency action on it.
Oh, yeah.
And we had a majority vote, but it wasn't enough for the 6-member thing. So the district attorney did its own evaluation and found
District or city?
The district attorney, the city and county district attorney did its own evaluation and concluded that it was a violation of the Sunshine Ordinance and ordered a cease and desist. And that letter was included in the packet. And so what I would like to move is for us to, I guess I have to move for us to have a reconsideration hearing on this in order to determine whether our precedent should match what the district attorney's ruling. I think the district attorney's ruling is new information, but I'm not asking you to decide that now. What I'm asking is a motion to have a rehearing consideration. And then if we decided that one.
You can just request that the item be put on the agenda for reconsideration. You don't have to make a motion. It's the
Okay,
chair's
then I will
prerogative.
request.
It's your
that-
prerogative.
Okay. Then if I don't need a
have me
motion,
do
then I request that this be put on the agenda for reconsideration based on the new information that there is.
And I will notify.
I just noticed it. It was weird.
I will notify our administrator to make it so.
And I don't know whether I guess this would go to you, Victor. If in that packet you could include how the district attorney got involved in the first place, I definitely would want that.
Absolutely no idea.
Well,
right, but when we put this in the reconsideration, whatever is in there about that would be helpful.
I have no idea where to get that from. I would have to go to the.
It's quite possible that
how
they
did the
found
district
it. There was a
attorney get
news
involved?
article about it, so it's quite possible they just read the news article.
The district attorney, essentially, it's the state attorney general, is the one who enforces the California Public Records Act and the Brown Act. They're the enforcement body for it. So that's why when you read in the ordinance where it says in 6734 that you can ask them for enforcement.
But was it the AG's office or was it the district attorney?
But
Because there
district
could be
attorney.
criminal, because there could be some type of criminal misconduct, which is why the district attorney would get involved. The district attorney is not connected to the AG's office.
Willful failure is official misconduct.
It would be from that, not
Right.
so it was not the AG's office.
No, I know, but the district attorney is an agent of the district of the state attorney general, aren't they?
No,
they aren't.
Kissimmee
They're
County. I mean, I think that there
completely
might be some
independent?
formal thing that all law enforcement officials are kind of part of the AG,
Yeah.
but
well, because
that's-
I know with my agency, there are certain things that we can refer to the district attorney, and there are certain things that can go to the AG's office, and it's a separate entity.
But either way, the DA has authority under 6734 to do that. So that's probably where they were coming from. So how they got involved, or somebody tipped them off. Who knows?
Can I ask? I wanted to ask: do we need to waive our complaint procedures to allow for the reconsideration? Because we do have the procedures for reconsideration. We would need to waive that procedure.
Well, it depends upon when you schedule this versus when we pass the.
I'm almost sure that our order of determination has been issued more than 10 days ago.
No, but isn't it?
But there
Isn't
was
it
no
10 days from? It's 10 days from.
I mean, honestly, I don't know if we need to waive that. I mean, can we not waive that after it's on the agenda? So no, this thing happened. This came to light at the Ethics Commission.
Oh, okay.
But it had been sent to the Ethics Commission on October 18th, and then somehow was marked as filed on October 23rd, but
Right.
then didn't show up until the November 27th packet. So it's a long process. here.
Anybody on the task force can request a reconsideration. It's not applicable to members of the public, parties that are parties of it.
So
this is an internal request.
I just wanted to clarify that.
Yes,
And
absolutely.
there's no order of determination because we didn't find a
I
violation. We didn't have
issue
the
an order of
numbers.
determination even if it's in the negative.
Okay.
So I understand that it's an internal process. It's not part of our complaint procedure.
Correct.
Thank you.
Correct. And what will happen is we will follow hopefully we'll pass the new procedure, but essentially it'll bring it back to the point just before the vote.
Yes.
And then the new information will be presented. We'll give opportunities for both parties to comment on it, so on and so on and so on.
Okay, and that would happen not at the reconsider. That would at the procedurally. Am I understand? We got to get out of here, but procedurally, it would be on the next agenda. Would be us to discuss whether to reconsider, and then depending on how we
I
vote,
believe
then
we've already determined if we vote yes on this, we will be determining that
we're not voting. I'm asking him to put it on the agenda.
We don't have it on the agenda to reconsider the item.
Is on the next agenda, we'll be considering whether or not we will reconsider.
Correct.
Exactly. Okay, that's what I understand.
Thank you.
That's
and
right.
and then it'll be a meeting following that one if we vote in the affirmative. The meeting after that would
Correct.
be
Thank you.
Correct. Absolutely. So, like any motion that was already made tonight for anything that was already on the agenda, while we're sitting here, if you wanted to reconsider one, you could. Because we're already in session for the items that are already on the agenda, they're already posted properly, that kind of thing.
Mhm.
This is now outside of all that. So,
It was agendized to take action.
right.
Is there a
exactly.
second?
We didn't think we need.
There is
I'm just
no
actually
requirement.
requesting it.
Okay, thank
Yeah,
you.
the
It's at the
request-
chair's
It's
discretion.
a request to put something on the agenda.
Thank you.
That's all. So, I'm just notifying you to please put it on some agenda in the near future.
Yes, I will.
Okay, great. All right, anything else? Call the next item. That's all I have.
Next on the agenda, announcements, comments, questions, and future agenda items. I have a few items myself. There is a requirement for all members of this body to do the harassment training video before the end of this calendar year. I did get your email. I will look into it and get you the passwords and so forth.
Yeah.
It's annual. I received the request to do it myself recently.
Yes.
The entire body must
Yeah.
do it before the end.
Everybody in the city has to do it.
Yeah.
Well, everybody that works for the city.
everybody that works with
everyone in the
yes.
city.
And maybe we should have everybody in the
should, yeah,
city,
maybe.
considering what's going on in the world, right?
Well,
December 31st.
Harassment prevention.
Yes, it's
Happy holidays.
approximately a 2-hour video from my understanding, but it takes quite a while to watch it.
And is it the one where you go too fast?
It slows you down, yes. You can't fast forward.
And we have to do the sunshine ordinance one also.
Sunshine, you must complete the training by the end of the year, but you don't need to submit the form verifying that you submitted
Until
it
it is-
until April.
yeah.
And when's their Form 700s due?
April 1st.
Okay.
So the
Is there an email out on those?
No, not yet.
So there's going to be a change next year.
Yes.
I think the Ethics Commission is moving those deadlines to the same time that you do those filings in April.
I don't have any answers.
So that way there isn't this disparity of deadlines.
And just to note that the Sunshine Ordinance Task Force will be meeting in special session on December 19th in place of the Education Outreach and Training Committee.
So everything that's on that agenda those are the only things that can be done. Can't make any, if you make any changes, it has to be done like immediately. Well, let us know, like tomorrow is
Oh, we
the,
start at 4, right? 'Cause the
Yeah.
education- Okay.
yeah, 4 o'clock, right?
Yes, it's a 4 o'clock start. The agenda has already been not published, but the notice has already been sent. It's some of our harder items, reconsideration for the Clark brothers and the Kevin Williams against Arts.
Oh, the reconsider, okay, let's make sure, even though we didn't get to the reconsideration tonight, I'm going to use it as the procedure for that reconsideration case.
Yes.
And we don't really kind of have to because we've already continued it several times, right? But just in case, I'll keep it in mind.
And it is my assumption that we'll be canceling the December 26th meeting of the Complaint Committee.
Okay.
Fine by me. Okay. Is that okay with you, Fiona?
Okay, yeah, sure.
I mean, if there are 3 people that would like to sit on it, then we can do it. If not, then we can.
Does City Hall even have someone to open the door?
I
on the
have to be here.
26th?
You have to be here. Oh, my.
We only have one day off.
If we cancel it, maybe don't have to be here? If we cancel it, do you not have to be here?
At
I
night?
could probably disappear, yes.
Okay. Okay, so if you guys don't mind, I would like to cancel it.
Yeah.
That completes my notes.
Okay.
I will literally be here if 2 other people wanted to be here. I mean, otherwise, we're kicking it.
It's just my thought that most of the complainants will not want to show up.
I would, yeah, that might be an issue. That's fine. Okay, next item.
That completes the notes. Next item
There
is
a
adjournment.
motion adjournment.
By rising vote.
So, okay,
Oh, yeah, by raising.
everybody's left the room.
The meeting is adjourned.
Thank you.
Is adjourned.
Thank you.